Yes.
I'm mentioning on behalf of MSN Soikia, my lord, item number 24, my lord. This matter may come up after Bihu holidays, my lord. Please unwell.
20?
After Bihu holidays, item 24.
List the matter after 2 weeks.
May I take the Lord? Back to mention for this thing. To urgent discussion for the after tomorrow, my lord. I have filed it, my lord. What happened in this case? Deputy Commissioner, after submission of application by the landowner, Deputy Commissioner, by a resolution of the DLC, has approved the, my lord, classification of land. After that, my lord, a letter was issued by the, my lord, Deputy General Manager NHIDCL, requesting him to not to entertain such petition. On that, by influence of that letter, minutes of the Deputy Commissioner was cancelled. That is challenge. Urgency is there because if a notification is issued, my lord, then thereafter our case will be infractious because after 3A notification, no consideration can be made, man. That is why urgency is there. Apply.
Wait, please. 35 beg to mention item 10 of today's executive. 35 beg to withdraw this decision with liberty to file again.
Why?
35 not enacted voted enacted in 5 minutes.
Let the matter come. We'll see.
Happy. What to be due concern of the other side, I beg to mention item number 36 and 37. If I see here I have
Yes. You have for that?
I've got a petition about it.
When do you want it?
After Bihu Day.
Is the matter after 4 weeks? Yes.
Me, I recommend item number 21. Part of material. Senior counsel to sample extract. May
20?
I say that this matter may either be taken up 23rd January or 5th February.
What is this pattern?
Your Lordship, regard to date stock of beer which were destroyed.
Oh, that matter.
Yes, Your Lordship.
Dead stock.
Yes.
Whether tax will be liable or not.
Yes.
Did it?
Yes. 23rd January or February, any day. Sir.
You destroyed it.
Yes, with due permission and supervision of the excise.
But why the stay? You have taken the inform the other side?
No, Your Lordship, I will.
Inform the
Yes.
then we'll see. Not now. Next.
I beg to mention item number 30. Maybe
1C.
13. 1C.
Yes. You want to withdraw?
Yes.
The learned counsel appearing on behalf of the petitioner, Mr.
SK Das.
S.K. Das, submits that he has instructions to withdraw the instant petition, and accordingly the petition stands closed on withdrawal.
Apply. May I your Lordship? Item number 29. 1 1.
Yes, what is it?
Your Lordship, my senior.
This type of submission doesn't work out yet. We'll see when
We
the
have
matter is
taken
done.
consent from us.
No. Try to do the matter. We'll see. I'll help you. Yes. Motion is mentioning is over, Mr. Sharma.
Hello?
Mentioning is over.
Oh.
Yes, madam, what is the instruction out here?
Present Patadar filed an objection that a suit is pending before the in Munsif 1 of 12.
Understood. All these things are understood. Now, what are you doing in respect to the miscase, the mutation order? Are you taking up any steps for that? After an order is being filed, order have been passed, that order has to be given effect. They want the mutation order to be passed.
Yes, sir.
Mutation order has been passed.
Yes, sir. Page 16.
What has not happened?
Uh,
Correction.
Necessary correct.
Correction is not done. So, if there is any objection by those people, then in that regard, don't you think that those persons should approach the appropriate forum? Isn't it?
He may appeal against the mutation.
You have to challenge the mutation order.
Yes.
But on the basis of objection being filed, they can very well reopen. But does the circle officer who has done the mutation have the power to review?
He cannot.
So the only course is that an appeal has to be filed
Filed.
against the court. So unless the mutation has not been cancelled, the question of not correction of the land records does not arise.
Yes.
If there is a stay in the proceeding, is there any stay in the civil court proceeding?
So far, mine that we are not
No, there is
aware.
a civil court proceeding something.
No, we are
Karan
not aware.
Pattata has filed a claiming that there is an ongoing case in Munsif over various cities. Additionally, the Secretary of Council informed the undersigned that the legal aid certificate issued number so and so was false. It is crucial to note that the final order of miscase number was based on the legal aid certificate issued on so and so. So under such circumstances, something has to be done.
Yes.
Okay. The instant writ petition has been filed by the petitioner. Being aggrieved by the inaction on the part of the revenue authority in not. Where's the mutation order?
Authority page number 16.
Huh?
160.
In not giving effect to the order dated. What is the date
There is date reflected in the order.
in the
Final
order
Yes.
passed in Miss case number 59/2022, thereby correcting the land records. Full stop. The record further reveals that pursuant to the said order being passed in Miss case number 59/2022, various steps have been taken by the petitioners representing before the Deputy Commissioner, Kualpara, requesting for correction of the land records in the name of the petitioner, who's being aggrieved by the inaction. The instant writ petition has been filed. This court, by the order dated 15/12/2023, had sought for instructions from the junior government advocate representing the Deputy Commissioner Gwalpara as to why the order of mutation has not been given effect to. Today, Ms. S. Borua, the junior government advocate, had placed before this court an instruction issued by the circle officer to the additional district commissioner RKG Gwalpara, wherein it has been mentioned that the mutation order which was being passed, that against the mutation order which have been passed, there has been an objection being filed by there's an objection filed by the current Pattada one Mr. Sair Ali. And full stop. It has also been further mentioned that there is an allegation to the effect that a legal heir certificate which was issued to the petitioner and on the basis of which the order was passed in Miss Case BL number 59/2022 was a forged document. Full stop. Be that as it may, the question therefore arises as to whether the patadar can seek an review of the order passed in Miss Case number 59/2022, taking into account that it is well established that the revenue authority affecting mutation does not have the power of review. The only course of events shall be available to the patadar would be to file an appeal against the order passed in Miss Case number 59/2022. Taking into account the above instruction which was placed before this court and is presently kept on record and marked with the letter X, this court directs the circle officer, Matia Revenue Circle, to grant to effect necessary correction of the land records on the basis of the Miss Case number 59/2022, subject to the say, which shall however be subject to such further challenges to the said order passed by the challenges which shall be subject to such other challenges to the said order if made by the if made. Full stop. The said exercise be completed within a period of 2 months from the date of the instant order. In the 2 months from the date a certified copy of the instant order is served upon the circle officer, Matia Revenue Circle. Yes, madam, what is the instruction? Why did you cancel?
He engrossed in the petitioner engrossed in the government and went back.
Yeah, the eviction has been already carried out. This is the instruction.
Not carried.
What is your basis to say that you are in possession of that land in dark number 515?
Sir, they have house over the land. They
Huh?
have the house over the land.
You have a house over the land. How do I know?
In application of the for settlement of land. Well, we have also annexed for the photograph all the relevant documents to that portion of the land. And also, my lord,
Which are the documents?
we have first, my lord, we have paid to the Bahira, that is basically Doromina.
2000, that is up till 2010.
Yes, it's the
Then thereafter,
thereafter, my lord, on page 21, there is electricity bill.
electricity bill does not show that you are in dark number 515.
Yes, we have house over the land. Plus, then we have page number 22, my lord.
we have annexed an affidavit
Affidavit for what?
while applying for settlement of land.
Yes.
Deciding on a plot of para 2, deciding on a plot of government land measuring 1 kattha covered by tag number 515.
So how did you construct the Assam type house? You must have taken some permission. How? Somehow, some permission. Then it will show the tag number 515. There must be, the house must have been assessed to GMC or the GMDA, assessed to the GMC or the Gaon Panchayat. Then also the tag will be shown as 515. Where is? Nothing is there.
Photostatic within a
I'm vacating the interim order.
within a short date.
Sorry. This type of matter shouldn't be there at all.
I think it's a short date. They become Friday because
No Friday business.
apparently while applying for Bhattara.
Yeah, you see, you are in Gaon. He's a permanent resident of 33 number Azra Gaon.
Yes, sir. This is in Ajara Gaon Panchayat.
Huh?
Yes, sir. This falls under. Yes, sir.
What?
This apparently the tag number is in village Pamuhi, under Moja Ram Sarani, which is Ram Sarani Moja is after Ajara.
Azra what?
Ajara resident.
Azara Revenue Circle? Is the Azara Revenue Circle?
370 is the notice. That is Adara Revenue.
And this is in Azara Gaon.
Sopropikoya Raja. Page number 8. Sopropikoya Ajara Raja.
Huh?
Page number 80. This is the vernacular version.
Hmm.
The bottom part. Sopropikoya Ajara Raja Sopro. Suppose Sopropika Kajota Ajara Raja.
The residence has been shown as FA Road. And what is this tenancy agreement?
Actually, what has happened that in few documents, my lord, actually, people, what has happened that, my lord, in few documents, our address was shown as, my lord, from
You know, what is this as agreement for letting out for RCC flat? Prahlad Burman with Vishwanath Mahato.
no, my lord, this I have annexed because, my lord, what has happened that in few of our documents, because prior to 2020, before we took possession of the land, my lord, it was annexed or our documents showed this address, my lord. Therefore, to show that we were earlier in this address, therefore we put this tenancy.
Huh?
Earlier, my lord, before we entered into the possession of this land, my lord, we stayed as a tenant in this rented place.
So you entered into this land prior to that, you were in this rented house.
Rented house.
Very well. This house is in 2017. Why you are saying that you have been there from 2020
No,
or 2010?
no. His brother was there.
Then?
His brother was there.
Then how this has relevance?
No, because what has happened, my lord, in a similar case, my lord,
Hmm.
what has happened, my lord,
Then you see your affidavit at page 22. So and so resident of house number 15 BC Lane, FA Road.
yes, my lord, exactly.
Then
Exactly, my lord. For
this
that,
is given in the year 2022.
exactly, my lord.
Then?
No. Therefore, I have annexed this document, my lord, be fair to this honorable court, my lord. The thing is that, my lord, prior to 2000, before he entered the position in this land, before I entered the position of the land, I considered it a rented place.
So you entered into the possession of the land when?
my lord,
Till
in
2022 you were there.
May 2005 I entered into the
It couldn't have been. You have filed an affidavit out here. See your affidavit at page 22 that you are a resident of FA Road.
My lord, yes.
Then you didn't say that you are a resident out there.
No, no, here is saying residing on a plot of government land.
Hmm.
My lord, this is because, my lord, what happens that once he has made a document, once I have made a document from a rented place, my lord. So for the convenience, my lord, all this document has already.
Your affidavit says that I am a resident of here, resident of house number 15, so and so, do hereby solemnly affirm.
I understand.
Then-
I understand, my lord. What I'm trying to explain here, my lord. The thing is that once my address was there in the rented apartment, so it has continued. So therefore, on that, for the convenience purpose only, it is.
Show me the house. Where's the house you were staying out there?
Yes, my lord. House is it, my lord? Page number, my lord, 19. My lord, page number 20.
This is the house without tin roof on the left hand side. Page 20. This is the house.
My lord, this- 19 is also there, my lord.
19 is what? This is the house.
Yes, my lord. This is what we have. This is the exact which is given
Hmm.
when you had applied for settlement of land.
Then?
We can put a clear picture.
Here the address is
Yes,
As
the
per
address
you-
is shown in page
Gorsu.
number 19. The address is shown as Gorsuk
Gorsu.
One.
Hmm.
Down below. Where does he live?
No, kindly see page number 19.
That is,
That is
Yes.
not, that can't be a house.
house.
and below that menu address is Gorsuk.
Gorsu.
This
Yes,
is something, some hardware store or something to that effect
Yes.
with a karahi out there.
If my clear picture, my lord, we'll put clear.
Huh?
We'll put some a clear picture. My lord.
I'm not going to extend the interim order. As they say that you have been already evicted.
No, my lord.
Evicted, no?
Yes.
This is the submission.
Then sufficient. That's
You want to place anything you place, that will be subject to outcome if you can show. Otherwise, you don't have any
my lord,
case out.
eviction has my
Heard,
simple
Mr.
solution is that, my lord,
M.
eviction has not
Bormon?
been carried out. Eviction has not been carried out. My lord.
They say that the eviction has been
Let
carried
let
out.
them put that in affidavit.
They have already stated out there. I will put it on record as marked as X.
Let them put in affidavit.
But I'm not going to extend this. Sorry. Not that these documents do not show. Further to that, if you want, I can very well dismiss it on the ground your affidavit in page number 22 categorically shows that you are a resident out there at FA Road. That is your statement.
That is only done for the constitution. My humble
Or
for that because all this address prior to entering into the position, my lord, has been in that address for that reason alone only. My lord. For that reason alone. My lord.
how can this person, the Azra Gaon, say that you are a permanent resident of there? Tell me. These documents on the face of it are false or fraudulent. Because how can he say on one hand, you categorically say that you have been staying in from 2017, you have entered into an agreement
No,
and you were staying out there.
No, my lord. What has happened that his brother is my lord, has been he and his brother were staying in this address, my lord, before prior to 2005. However, his brother stayed in the house and we came out of that house and stayed in this current address, my lord, in Pamuhi, whichever is the address, my lord, where it is sort of evicted. But however, my lord, we could not find a rent agreement of that period of time. But since his brother has continued to stay over the land, therefore we have brought this rent agreement, my lord. That is the only reason we have brought this. Otherwise, had we found, my lord, the rent agreement of 2000 prior to 2005, we could have annexed that, my lord.
And why do you say 18.3 will apply? What is your basis? What reasonable opportunity you want?
So we have been, I understand, my lord, that
How is 18.3 involved?
Uh,
This will be a case on 18.2.
My humble submission clearly bona fide use.
You have a?
My humble submission, very narrow submission on that, my lord,
Yes.
that we are using the land bona fidely by paying the base of this what I have.
My goodness.
Well,
Well,
the
that's
error.
18.2 says bona fidely using.
It's also an exception for my lord bona fide.
No, not bona fide use. Kindly see.
Property is the
See the language out there. 18.2 says what? You look into it till by the time what do you want? I give you two up. I dismiss the writ petition. You go and file an appeal. That's the one. The second is I vacate the interim order. Which one? Either. I give you two up. Being a New Year's, you are appearing for the first time out here. So I give you two up. Either take a dismissal, go and file an appeal, or vacate the interim order because of the stand with the.
make it.
The third is not available.
No, if my first call, humble submission, that my application for Vasudha may be reassessed again. My lord, that the decision can be disposed of with the grounded, my lord, that can be reassessed again whether into the position or not. We'll submit to that. That, my lord, they have said that first of all, my lord, my humble submission is that eviction has not been carried out because, my lord, we approached this court, the status quo order was there on last order. So, my lord, no eviction has been carried. That's my first
They
question.
say that you have been evicted on 10/11/2000,
No.
April 2023.
No, my lord, that is the wrong. Sorry, that's not a fair. Secondly, my lord, my Vasundhara application has been rejected only on the ground that date 30.
That you are not residing there.
Hello?
That you are not residing there.
Yeah.
Yes.
Sir, it can be disposed of with the ground, my lord, that my application for Vasundhara can be reassessed again on that ground, my lord.
The instant writ petition disposal. The instant writ petition has been filed by the petitioner being aggrieved by the rejection of the application seeking settlement as well as also the notice dated 18/12/2023 issued by the Circle Officer Azara Revenue Circle directing the petitioner along with two others to vacate the land within 3 days. From a perusal of the writ petition, it reveals that the petitioner claims to be a resident of Pamohi Gao Gorchuk in the district of Kamrup Metro, Assam. Full stop. It is the further case of the petitioner that since 2005, the petitioner has been residing in Dag number 515, which is admittedly a government land, by constructing an Assam type house. This court at this stage, however, finds it relevant to take note of that there is no document shown that any permission was taken for the purpose of construction of the Assam type house, or any photograph pertaining to the Assam type house was placed before the court. The petitioner further states that he had been paying the Tozi Bahiri till 2010, and thereafter no Tozi Bahiri was accepted by the government. This court, however, finds it also relevant herein to mention that Tozi Bahiri is a form of a penalty for unauthorized use of the government land. Be that as it may, it is very pertinent herein to mention that the perusal of Annexure 6 to the said document shows that the said document is dated 24/2022. On the other hand, it has been mentioned that there is no Tozi Baheri was accepted by the government after 2010. It is further relevant to take note of that the petitioner claims that he had applied for settlement through the Vasundhara scheme on 210 or 21 on 2/1/2023. But the said application was rejected on 14th of November 2023 on the ground that the applicant was not in possession of the land in question. Full stop. It is under such circumstances the petitioner being aggrieved. No, full stop. The petitioner further, the record further reveals that pursuant to the rejection of the application for seeking allotment on 8/12/2023, the impugned notice was issued to the petitioner along with two others for vacating the land in question. The record further reveals that upon the writ petition being filed, this court by an order dated 20/12/2023 had directed the responding authorities to obtain instructions in the matter. And further, there was also a direction that till the next date of listing, there shall not be any process of eviction with regard to the plot of land reflected in the impugned notice and the status quo as regards the possession of the land as on 20/12/2023 shall be maintained. Today, Mrs. S. Borua, the learned counsel, appearing on behalf of the respondents, and more particularly the Deputy Commissioner, Kamrup Metro, as well as the Circle Officer, Azara Revenue Circle, had placed before this court an instruction dated 8/1/2024. From a perusal of the said instruction, it reveals that the petitioner herein had encroached the land pertaining to government dark number 515, for which the notice under Rule 18(2) of the settlement rules was issued. It was mentioned that the petitioner had not submitted Tozi revenue receipt till 2010. It was also stated that from the voter's I-card, which had been enclosed to the writ petition, it reveals that the address of the petitioner is at 18 FA Road, BC Das Lane, Guwahati, Bhorlumukh. Further to that, it has also been mentioned that the particular plot of land, the eviction was carried out in respect to the particular plot of land on 10th and 11th of April 2023. However, it was subsequently observed that the land was again encroached by the petitioner, for which a notice had been served before 15 days prior to eviction. It was also noticed that the petitioner had started construction again 3 days. Had again started construction, for which 3 days was mentioned in the notice to halt the ongoing construction.
But it may be recorded. It be recorded.
Let me complete.
Sorry.
It has also been mentioned that the petitioners had visited the office of the circle officer Azara Revenue Circle, wherein it was told to them to vacate and sufficient time was granted. It was categorically mentioned that even before the receipt of the court notice, eviction was carried out. Mr. M. Burman, the learned counsel appearing on behalf of the petitioner, submits that the instructions which have been placed by Mrs. S. Borua are misleading, inasmuch as no eviction was carried out by the respondent authorities till date.
That's to Tosi Bahari also, that might not record it. But it's not a protest of.
Huh?
But they say that they have not paid the Tosi Bahari Amalot. That is, it's also my stuff that they have paid Malot. This is also a valid document. And secondly, my lord,
Mr. Counsel,
secondly, my lord,
I was supposed to pass some favorable orders to you.
I'm so sorry.
But if you want, I can very well dismiss. Kindly come to paragraph 4 of your writ petition.
I'm so sorry.
You say that it is pertinent to maintain that Tosi Bahari has been paid till 2000 and thereafter no Tosi Bahari was accepted by the government. Now you see this particular document at page 25. This document is dated 24/2022.
Yes.
How are you mentioning that after 2010 they have not received? Isn't it on the face of it false? So kindly don't go into this Tosi Bahari business.
Sorry, my lord.
Yes. I've heard the learned counsels appearing on behalf of the parties. It has been a categorical stand of the petitioners that the petitioners have not yet been evicted and the Basundhara and the settlement application was rejected without taking into consideration that the petitioners were actually in possession, the petitioner was actually in possession of the land in question. This court have also given an anxious consideration to the said submission and is of the opinion that if it is the case that the petitioner are in possession, were in possession of the land in question and the application was rejected on the ground that the petitioner were not in possession, then it would result in passing of a rejection of the application for settlement on a non-existent ground. Full stop. Be that as it may, this court cannot also be unmindful of the fact that the respondent authorities have categorically stated that the petitioners were evicted in the month of April 2023. And thereupon, the petitioners have again tried to encroach. If that be so, then in that case, the rejection of the application for settlement would not be on a non-existent ground. These aspects of the matter, however, would require an adjudication to be made by the authorities concerned as to whether the petitioners at that point of time were in possession of the land in question. This court therefore directs the Deputy Commissioner, Kamrup Metro, either by himself or through his delegate, cause an inquiry as to whether the petitioner was in possession of the land in question. And thereupon, if it is found that the petitioner was in possession of the land, then in that case, and has been in possession of the land since 2005, then in that case, the application for settlement be reconsidered. However, if upon the inquiry it is found that the petitioner was evicted and was not in possession of the land since 2005, then in that case, the question of again revisiting the application for settlement would not arise. With the above, the instant petition therefore stands disposed. X হিসাবে মাপ করছি, instruction X হিসাবে মাপ X করে Yes, you got 5 lakhs
Yes, Lord.
and the remaining 5 lakhs you have not got. Where is Mr. D Nath? Call up Mr. D Nath, we'll find it out.
File up.
First, this is conduct petition. The first petitioner submitted the certified copy of order pro register and relevant portion of
Has this notice been received?
first
Mr. Counsel, earlier also I told you. Why, what is your difficulty in getting it served in his office? The problem arises is, first of all, whether this document has been served or not. How will you know?
as per track consignment
Where is the track consignment?
we have not annexed.
Then you should serve it to them by hand.
Lordship had this notice may be
Huh?
notice may be issued here, Lordship, whether they receive or not, they will decide.
Issue notice making it returnable on 19th of February 2024. Steps be taken upon the respondent number 1 and 2 by way of registered as well as you.
Lordship, keep your
But in this case, my lord, Krishna, my lord, is an elected member of Dokhin Bogorobari Gaon Panchayat Samabay Samiti Limited. Sir. After election of the petitioner, my lord, a registration was filed before this court, my lord.
Yes, Mr. Talukdar, we have to pass a similar order.
I have little reservation.
You can't have I can't pass any other order now because in the respect of this, when the order was being passed, they were against 3 persons, more particularly. There were 3 persons.
4 persons.
No, 3 persons at that trial. If you see the impugned order dated 4/7.
4 persons, my lord. Last paragraph also.
No, 4/7. No, kindly come to page 26.
Yes, I am on 26.
Last
Last
penultimate
paragraph also,
paragraph.
and the
As
pen-
alleged, it has been observed that so and so were allowed to contest without having the eligibility.
Yes.
Okay. Now this person, Monowara
Yes.
Khatun,
Yes.
had moved the application and Justice Sham has passed an order.
I'm on that, my lord. Because your lordship will see, your lordship will consider my submission.
Mr. Talukdar, if it was a case,
Yes.
when I was taking up this matter for the first time, I would have dismissed the petition on case.
Correct.
But as of now, I am not, because unless dismissing would be prejudicial, because the other two have, more particularly the other one,
Yes.
is already enjoying a stay order.
My lord, only one submission lordship will consider. So far as the first order is concerned,
Hmm.
that was passed on the ground that there are no allegations against my lord 11 members. So therefore, my lord, the impugned order was stayed in respect of the 11 members. Subsequently, my lord, Monwara Khatun, my lord, approached. Your lordship will see page 33, what
Hmm.
this honorable court, my lord, has recorded.
Hmm.
My lord, I take your lordships, my lord, to the second paragraph, last 3-4 lines.
Hmm.
The writ petitioner has approached this court by filing this writ petition inter alia contending that the allegation brought against her are totally unfounded.
Where?
My lord, page 33. Yes.
Yes.
So therefore, while considering that case of the petitioner, Manwara Khatun,
Hmm.
the honorable court found, and therefore, my lord, passed the order that, my lord, the findings of the register is absolutely unfounded.
Hmm.
Now, here what I am trying to say, my lord, the petitioner has not made out a prima facie case to show, my lord, that the findings in respect of the petitioner, my lord, are perverted.
But where is the finding out here?
No finding.
No,
But
no,
that
no.
case is, that was
No,
considered.
Mr. Talukdar, we can do one thing, we'll issue notice.
No.
No,
leave it to your
kindly,
lordship,
no,
my
no,
lord.
kindly
I'm
appreciate.
just pointing it out, my lord.
I understand everything.
My lord.
I've looked into the file.
My lord.
But the only thing is, what I have seen out here that this court is tied by disorder of
Correct.
Justice Sham.
That I leave it to your lord.
I have no other option
My lord.
but to issue it. Only thing I can help you out is take these matters and fix it because there is no date fix out here.
My lord.
So we can very well
I
club
leave
it
to your lord.
and fix it sometime
Correct.
after the vacation.
Correct.
I think that is the best way
My
out.
lord.
Issue notice making it returnable on. Now we fix the other two matters
My lord.
together.
Lordship, take up together.
Fix, yeah, you file your affidavit out there, whoever you want. Because
My lord.
another thing is, this order of 4/7
My lord.
is passed against on the basis of a petition filed by one Moidul Islam and three others.
my lord.
You can still get it. Now, whether these people are made parties out here, no. You see,
Yes.
that is the problem. And none of the other petitions also, these people are made parties. It is at their behest that the secretary has taken, because this was 110.
No, my lord,
Is
perhaps
it
it was,
100 and what is the what proceeding is this? 100 or 101 or 110?
my lord, I think this was a Rule 27 proceeding. I don't know, my lord. I have to check it up.
Rule 27.
Because after election, my lord, that has been cancelled. So essentially, it needs to be 27.
There was a what he has done out here, 47, there was a confirmation being made by the Eastern Register, which was cancelled.
Or then it will be 111.
111.
Right.
So I think it is a 111 proceeding.
Right.
Now, when the 111 proceeding is done at the behest of those, these people needs to have been made a party,
Yes. yes.
which have not been made in either of the
Right.
parties.
Those cases, my lord, those points will come in the, my lord, main argument,
Huh?
final hearing.
No, in the others, I think he is there.
The other repeats
Moidul
also, they have
Islam.
not been treated as part.
They are not. Okay. Issue notice making it returnable. You can file your affidavit by when?
My lord, till now I have, my lord, sent, my lord, I have thought for the instructor. My lord, till date I have not received. Lord, will you kindly grant me 2 weeks time? In the meantime,
Okay,
again,
will
I'll, my lord,
issue
give a
notice
reminder.
making it returnable on 12th of February,
My lord, correct.
12th of February 2024. Full stop. Mr.
Okay.
SK Taluka appears on behalf of the respondent number 2 and 3. And Mr. Who appears for whom?
Actually, on the person, it is indirectly.
This is misnomer, my lord.
It is corporation department. Subsequently, it was directed.
We have corrected.
Corrected.
Where? Oh, correct. Appears on behalf of respondent number 1, 2, and 3 and accepts notice. Extra copies of the writ petition be served upon him during the course of the day. This court have also duly taken note of the fact that taken note of the order dated 4/7/2023 by which the election of the petitioners have been set aside, has been set aside, and the confirmation which was given by the assistant register of cooperative society was cancelled. Full stop. It is also taken note of that similar writ petitions are pending on the same, and it is also relevant to take note of that on the same dispute, 2 other writ petitions are pending, wherein the coordinate benches of this court have passed interim orders not to give effect to the order dated 4/7/2023. So taking into account the above, this court is also, in order to maintain the uniformity, passes a similar order to the effect that the order dated 4/7/2023, so passed by the Register of Cooperative Societies, shall not is stayed insofar as the petitioners are concerned.
Obliged.
The respondents shall file their affidavits on or before 5th of February, and the petitioner would be at liberty to file their reply on or before the next date. Full stop. This court further directs the registry to list the instant writ petition, list WPC number 4099/2023 and WPC number 4896/2023, along with the instant writ petition on the next.
Obliged.
Alright.
Mr. Nath, this is another matter. You say you have given, if you see the order, where is it? Anyway, this is an amount of 10 lakhs which was duly sanctioned at the time when the writ petition was there. So you said that within 45 days the money will go to the DLSA. Just find out, but I'll have it on Wednesday, Friday. Just find out what is the status of it. as to whether the money has been paid to the DLSA. Because if one is it is paid, then I'll take it up with the DLSA.
Lordship,
Because
I'll-
keeping this, this is a rape victim who was given this 10 lakh as per your scheme. Give to him this thought. It will. He is conducted. Now, what has happened out of this 10 lakh, 5 lakhs has been paid. Remaining 5 has not. Kindly see on top, you have also stated out there that this amount has been already done, which will be given out
Yes.
there 45 days.
Yes.
Now, out of that, only 5 lakhs have been paid, 5 lakhs have not.
I'll take the instruction.
List the matter on the next day when
Right.
it ready. By the power take.
Up.
Just take an instruction.
Up.
Yes, yes. Mr. Counsel, give a copy of the petition to Mr. Nath. Okay? We'll see to it.
Alright.
I'll have it on Friday.
The issue pertains to expansion of a road which is maintained by the PWD Assam. My lord,
Yes, are you acquiring the road?
Lordship, I have to take instruction, Lordship.
Then they are constructing.
my lord, the demolition process has already started 6 December. They have not reached our plot till now, but then they have started from the highway side. But the deputy commissioner had asked the circle officer to put up a report on this. Lordship would look at case 21. The constant circle officer, the ATC revenue was asked to put up a report on there. No action has been taken. This was in September 2020. Case 21.
But till now, it has not affected you.
My lord, it is almost reaching us. Some of the houses have gone. In fact, there are 52 persons who have signed this representation.
Ah.
They have not all come before this court in this representation. Some of these persons are already affected, my lord. out of these 52.
Will issue notice, short notice. Issue notice making it returnable on 24th of January 2024. Mr. B. Chaudhary appears on behalf of the respondent number
5 and 6.
5 and 6. Mr. S. Tatta appears on behalf of the respondent number 1. And Mrs. S. Burwa appears on behalf of the respondent number 2, 3, and 4. As the respondents are duly represented, extra copies of the petition be given furnished to him during the course of the day. The case of the petitioner herein is that the petitioners are owners of the land in question, wherein there are certain steps being taken by the district administration along with the PWD for expansion of the what road? Dhemaji.
Existing Dhemaji Civil
Existing
Hospital.
Dhemaji Civil Hospital Road. And thereby, the petitioners apprehend that their lands would also be acquired, the possession in respect to those lands would also be taken without following the due process. Full stop. This court is, however, not inclined to stay pass any interim is not inclined to pass any interim order as regards not to demolish the properties of the or over the land of the petitioners. But this court makes it clear that if in the respondent authorities proposes to do so till the next day, then proper acquisition proceedings should be initiated prior thereto.
They have not given us a notice also.
This will help you.
Well.
Your final relief is that
That is,
that
we are
the
not against
acquisition
that.
without acquisition they should not. So I say that till the next day they would not. You can go ahead by making a second pre-notification.
7.
Deeply.
Yes, who is appearing for social welfare?
Your Honor, this is a very,
Yes.
very sad reality of today now.
Social welfare, who is appearing?
For social
Yes,
welfare, I
you are
can
social justice.
social justice.
Yeah, what do you do in case of
We
a
have-
person who is around 75 years old? The husband, daughter-in-law creates a nuisance. And
That's
what
I-
do you do as regards the electricity and all these problems? She is facing the electricity has been disconnected and all.
No water.
No water. She can't survive. She's an old lady.
And she
I-
doesn't, she's a property owner. She doesn't have to be shifted to a home. That's the only provision they have. It's that
No,
sad.
no.
This
And
country
then
is
in that case, the
that
police
situation.
police needs to do something, step in.
They have filed FIR also, but still not any action has been done by that.
Understood.
I-
So
I-
you submit your report. We'll have this matter again on 22nd.
I just want a few, I want to bring to the table a few things. The police, the IO, he went knock, didn't open the door.
Huh?
When he went to visit the respondent, they didn't open the door. They are used to handling the police in a way that the police cannot break the barrier. Because this boy, he has created atrocities towards his father, brother. He's a veteran. He got his elder brother admitted in Gurgaon after hitting him with the dumbbells, nearly dead. And father was shot.
Madam, all these things will be heard later on. Let me first get a report from these people. Okay. Issue notice making it returnable on 22nd of January 2024. Miss S. Borua appears on behalf of the respondent number 1, 3, 1 and 3 and Mrs. R. Deka,
Respond number 4, your lord.
2 and 4.
I have social welfare. Social welfare is different.
Okay, I repair for 1, 2 and 3 and Mrs. S. Deka appears on R. Deka appears for respondent number 4. The petitioner would take steps upon the respondent number 5 and 6 by way of registered as well as usual. Full stop. Further to that, petitioner is also given the liberty to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. This court, taking into account the allegations which have been made in the writ petition and writ petition, and more particularly to the fact that the concerned respondent authorities have not taken due notice to the representations as well as the FIRs being filed, seeks a report from the concerned respondent authorities, more particularly the officer in charge of the Panbaja police station as well as why have you made the Dispute police station as well as the director of social welfare. Director of social welfare you have?
Social justice and empowerment.
You have a director of social welfare as to what further steps is required to be taken in this regard to redress the grievances of an elderly, of a senior citizen who is around aged about 75 years. Full stop. This court further directs we'll have it on 19th. This is in matter is urgent, not on 22nd, 19th. Huh? You get your report. A copy of the instant order be served upon Mrs. S. Borua and Mrs. R. Deka for taking due for effective compliance with directions so passed.
The year 2016, the government of India had framed.
Yes, madam, you are appearing for
PNR.
PNRD. Why you're not giving them her the amount? She's entitled to some 1 lakh.
Some amount. First, it's
How will she make a house?
actually by the second.
Yes, you should notice. You should notice making it returnable on 29th. You have it on 29th of January 2024. Means which appears for housing? Chief Secretary 1, 2, 1 and 2. Housing, you are 1. Mrs. S. Bulwa appears for response number 1. Ms. So appears for response number 2. And Mrs. So Jibora
Canberra.
and Bora appears for response number 3 to 6.
Or
3 to 6. So as the respondents are duly represented, extra copies of the petition will be served upon them during the course of the day. The grievance of the petitioner herein is that the petitioner, who is a person who is a person suffering from 90% visual impairment,
suffering may not be.
Huh?
The word suffering may not be.
suffering may not be you.
It's just visually impaired. He's
It,
visually impaired with
yeah.
90% impairment.
The case of the petitioner is that the petitioner who is with 90% visual impairment and belonging to the poverty line, below poverty line category with no source of income, have not been provided the benefits of the Pradhan Mantri Awas Yojana Gramin scheme. Though the petitioner had represented before the respective authorities to do so. The respondent shall apprise this court on the next returnable day as to why the petitioner's representation have not been taken note of and have not been redressed. Yes.
Before the petitioner starts, Lordship, I have instruction to appear on behalf of the we haven't been served.
I will ask you when you want.
My lord, here, my lord, private respondent number 7, mortgage, my lord, one plot of land, my lord, his plot of land, my lord, page 87, my lord. But now, my lord, our land is being, my lord, sold out.
Why you are not going under section 17?
But they are, my lord,
Go, Surface, DRT. Go there. Go there. That this is your land. How am I going to see that this is your land or whose land? Mr. A.M. Bolvia, the learned counsel appearing on behalf of the petitioner, submits that he would not like to press the instant writ petition. However, press the instant writ petition. So he submits that he would take appropriate steps in terms with section 17 of the that Surface Act of Food Form to securitization of and reconstruction of something on Mumbai Act of I'll tell you the name. Wait, where is that name? He also has not written the full name. Yes, what is the full name?
Lordship, securitization and reconstruction of
Page
financial
87.
assets and enforcement of Security Interest Act 2002.
Stands. Taking into account the above, the instant writ petition stands closed on withdrawal. However, the withdrawal of the instant writ petition shall not prejudice the petitioner in filing appropriate proceedings under the provisions of the above act against the impugned notice for sale. Yes,
Lordship, parcel of land measuring 2 kathas.
you wanted to withdraw this?
Sir.
Why?
If I have not annexed the representation I filed Annexure 14. Actually, it was my mistake. I gave comment.
But the thing is, you have earlier approached this court.
Right.
You have categorically mentioned that you have no problems with the other lands.
No problem.
You are only concerned with the 2 kathas of land which have been allotted to your father, isn't it? Now what they have done,
They have come as per the direction of this honorable court, but after coming, they have demarcated some other land, which is
and you have filed an, you have, you have filed a petition for demarcation.
Lord.
And they are not demarcating it.
they have not even demarcating the land which is settled to my father. They are demarcating some other land. Actually, was in some other dark number.
Hmm?
A culvert road to that.
Which representation?
My lord, that I have not filed. But after the court
To do one thing, file an additional affidavit, bring on record the representation.
I will file the representation.
Or you want to file a representation, you want to withdraw that. The learned counsel appearing on behalf of the petitioner, Mr. So-and-so, submits that instead of filing the instant writ petition, instead of proceeding with the instant writ proceedings, he would like, he has instructions to withdraw the instant writ petition and represent before the concerned respondent authorities. Taking into account the above, the instant writ petition stands closed on withdrawal. The withdrawal of the instant writ petition shall not prejudice the petitioner in representing before the authorities concerned. Yes,
Yes, Your Lordship. Lordship, this petition relates to non-partition of certified copy of miss case number 12 by the additional district commissioner revenue.
yes, why you are not giving?
Take instruction. I have. Take
What instruction you require? Give it. Why should we keep this matter pending? The instant writ petition has been filed by the petitioner.
He also refused to accept the
Madam, not necessary. You want that documents. That's all.
documents and allow my counsel to appear.
Absolutely, you will be the. You have no objection in his counsel appearing. No matter. Why should we fight on this? Silly? The instant writ petition has been filed by the petitioner being aggrieved by the conduct of the additional district commissioner revenue Soraido in not furnishing the copy of the complaint as well as the orders so passed in miss case number 4/2023, in respect of which certified copies were sought for, as well as also being aggrieved by the action of the respondent, action of the additional district commissioner revenue Soraido in not allowing the petitioner to be represented by a counsel. Mrs. S. Borua, the learned counsel appearing on behalf of the additional district commissioner revenue Soraido, submits that appropriate directions can be passed by this court, directing the concerned official for providing the certified copies of the complaint petition along with the enclosures and the orders so passed in miss case number 4/2023. This court, upon hearing the learned counsels appearing on behalf of the parties, is of the opinion that if any proceedings have been initiated against the petitioner on the basis of a complaint, then the petitioner has a right to know as to the contents of such proceedings, as well as all such orders which have been passed in the said proceedings. This court also does not see any bar under the provisions of law, thereby debarring the representation by a counsel. Therefore, in view of the above, for the interest of justice, this court disposes of the instant writ petition, thereby directing the additional district commissioner revenue Soraido to furnish copies of the complaint in miss case number 4/2023 along with the enclosures filed therewith, if any, and the orders which have been passed. Full stop. Passed. The said exercise be completed within 10 days from the date a certified copy of the instant order is served upon the Additional District Commissioner Revenue Soraido, which the learned counsel for the petitioner submits that she shall advise his counsel to do so on or before 19th of January 2024. Full stop. This court also directs the Additional District Commissioner Revenue Soraido to permit the petitioner to be represented by a counsel in Miss Case number 4/2023. Full stop. With the above, the instant petition stands disposed. Yes, Mr. Bodloy, why are you not taking any action?
Lordship, otherwise they have filed a representation on 6th.
Not only filed a representation, there has been various reports,
Yes,
everything is there. Why you are not taking any action? You were the register of cooperative society is in session of the matter.
Yes.
There are reports which have been given by all these formality, various authorities who have given the report have categorically stated that this particular society is cooperative society is running in a very
Yes.
sad state of affairs. Then isn't it the duty being the head of the
Yes,
here take appropriate steps?
Yes.
You should need notice out there and ask do it quickly. Issue notice making it returnable on 9th of February 2024. Mr. G. Bodler appears on behalf of the respondent number 1, 2,
6, Your Lordship.
3, 4, 5, and 6. As regards the respondent number 7 to 9, the petitioner is directed to take steps by way of registered as well as usual. By 12/1/2024. The Mr. G. Bodler shall also be served with extra copies of the notice of the writ petition on or before 12/1/2024. This court have also duly taken note of the contents of the writ petition, wherein there are various serious allegations which have been made against the cooperative society, that is Assam Bahumukhi Samabhai Samiti Limited, and the inaction on the part of the register of cooperative societies to the complaint which have been lodged and is presently pending. Full stop. This court directs the Corporation Department to file an affidavit on or before 2nd of February 2024. The petitioner, in the meantime, would be at liberty to file the reply. Thereafter, would be at liberty to file a reply on or before the next date. This court further makes it clear that the pending of the instant writ petition shall not be a bar on the part of the registered cooperative society to take such decision as deemed fit in such decision in accordance with law on the complaint which is presently pending.
Deeply obliged.
In the morning, I mentioned that I could not inform the other. Now I can
You want an adjournment? Item number?
to come up on 23rd January or 5th February.
Okay. It's the matter on 23rd of February.
wrongly listed here, Lord.
They're wrongly listed.
Yes, sir.
It's the matter before the appropriate bench, taking into account that the writ petition is filed against an order passed by the foreigner's tribunal.
Lordship, this matter pertinent to SKRS here. Here, Lordship claim under SPM notification dated 15/11.
Dispose of
Tip here.
4 months, 4 months, 4 months. Huh?
Yep.
Dispose of. Nah, TR Mohan. Yes.
Tip.
Yeah, একেটা আছে order আছে and with where is the petition? This is absolutely a private dispute.
Lord.
What does the government have to do out there?
The government land.
Huh?
The dispute in the government land.
In the government land?
Lord.
No, the government has no business out here. Here there is a dispute that some 22 bighas of land,
Look.
which is in possession of somebody,
Private
of
respondent.
them.
Look.
The private parties are disturbing.
Look.
So it's a civil court.
Look.
No, but they are saying that this is a Invel Patta land.
Sorry, Your Lord. Sorry, Your Lord.
Why are you not filing a suit? You have to file a suit.
I am only agree.
You are only agree with the private respondent.
Yes, Your Lord.
Then it
They
is
are
between
giving-
you and the private respondents. Go and file a suit.
Because the land has not yet been allotted in our.
Not necessary. It is on the basis of possessory right.
Your Lord.
So
We
you
have
will be
also applied for. giving us-
whatever may be, that is a different thing. You are not asking for. Your basic thing is that in respect to this 29 bighas or 22 bighas of where after they have got the right title in respect
12
to the
bighas.
other lands,
12 bighas.
they are now eyeing your other lands,
Yes.
your land,
Yes.
isn't it?
Total
That is-
29 bigha, 12 bigha was decreased in their name.
And
What-
remaining 17 bighas, they are now eyeing on your
One
land.
bigha has already been given as patta. Now about 15 bigha, which
So-
are alluvial line, accreted from river Barak.
So-
we are cultivating there here.
So go there, file a suit. This can't be here. This court can't decide this.
Can it be your lot? We have made a representative, the superintendent of police and deputy commissioner.
Mr. Counsel, let me tell you what. If today this court directs anything to those superintendent police, this court will be directing the police to interfere between a civil dispute between you and the private respondents. This will be a serious consequence at a late stage. So it would not be good on the part of this court to direct the police to interfere. In all other cases, then they will be doing it. So, and there is also a circular whereby there is a specific direction that private disputes, the police should not interfere.
Here is a case, they have taken the help of the local police, your lord.
So but get an injunction in the trial court. You have to get an injunction that you are in possession of this land, your possession should not be disturbed.
That you can do,
Yeah,
your lord.
yeah.
And there is no harassment, your lord. There
What
is
no harassment?
We are cutting
No,
our crop.
you are the harassment is done by whom?
Private respondent with,
So
the,
you want the issuance of a writ against the private respondents?
with the help of the local police.
Local police or not, that is the material out there. You have to get an
Now it is
injunction.
a harvesting time, we are not able to cut our crop, your lord. As your
Undue harassment to evict them.
As your lordship,
You file a suit. Get a file.
that will
The
be,
learned counsel appearing on behalf of the petitioner submits that taking into account that the dispute pertaining to the land in question is primarily between the petitioners and the respondents, private respondents. Which falls within the realm of the competent civil court. He would not like to press the instant writ petition. The learned counsel, however, submits that he would like to withdraw the writ petition with the liberty, withdraw the instant writ petition. He, however, submits that withdrawal of the instant writ petition should not prejudice the petitioners in approaching the competent civil court. Taking into account the above, the instant writ petition stands closed on withdrawal. It is, however, made clear that the withdrawal of the instant writ petition shall not prejudice the petitioners to approach the appropriate civil court.
17.
May please. This is a particular non-funding of a provision by another right.
Mister, you have already been granted the relief.
No.
Yes. All information is to be given to you. That has been given.
No, Lord.
Yeah.
It is
Kindly
a-
come to page 18. Page 19.
This is the order of the second appellate.
Yes. So they have already given the, yeah, but they are not providing the information.
Lord, that is
That is it.
that is the
Now, that particular section, section 20 or 21, categorically mandates that these Assam State Information Commission or the State Information Commission has the power to deal with them if they don't do so. So why you are not approaching them if they are not giving it?
again the petitioner file another representation before the Lordship, the Chief Commissioner. That is Lordship will find it at page 20.
No, then what happened?
Nothing was different, Lord. Even till today, Lordship, the no input is furnished with me.
So this was given on 10 days. Then what happened? After 10 days,
No, Lord.
then have you been there?
No.
Why? You have to tell the Assam Information Commission out there saying that yes, you have directed within 10 days, but then also they have not done it. There is a power out there that this person can be sent to jail. These are very serious powers these people have. Isn't it? Right to Information Act. Hello. Right to Information Act. File an application out there for putting these people behind bars. Because here, if I issue notice only, it's not going to help you. You are not going to get anything. It will take a long time. Kindly see here, penalties. Where the central or the state information, as the case may be, at the time of deciding an appeal is of the opinion that the so and so, without any residual cause, refused to receive any application of so and so, malafidely denied the request of the or so and so demand, it shall impose a penalty of 250 rupees each day till the application is received or the information is furnished. However, provided that the central experience, so as the case may be given a reasonable opportunity of being heard here, whether here or so and so as the case may be at the time of deciding of the complaint without any reason, fail to give an application, give an application. So kindly ask them to take the action on the 20. You see, then things will move. I'll only issue notice, then one fine day this matter will come up after 2 years. It is not going to serve your purpose. I think you better move under section 20.
By this letter dated 2023.
They had directed to give you within 10 days. They have not done so. Then why are not moving an application under section 20 for taking action against these persons? I think better off there. Then obviously they will. Once you take disciplinary action against those people, they know how to do it. The Learned Counsel appearing on behalf of the petitioner submits that taking into account section 20 of the Right to Information Act 2005, he would avail such remedies before the Assam Information Commission by filing appropriate application. Taking into account the above, the instant petition therefore stands closed with the liberty given to the petitioner to approach the Assam Information Commission in terms with section 20 of the Right to Information Act 2005. This court further, taking into account the various orders which have been passed by the State in Assam Information Commission, observes and directs that the Assam Information Commission shall take appropriate action in terms with section 20 if the information 20 of the Right to Information Act 2005, if the information which have been directed to be furnished has not been done so by the respondent authorities after following the due process.
Right.
Why is this matter under 226 and 227? Not
What-
a 482 or 440, what is it? 401, 397, 42.
Lordship, perhaps the impugned order of the sessions judge makes
This is an appellate order of the session judge.
yes, and but his has come through the 226 route, perhaps Lordship, because the impugned order talks about a report that must be submitted by the DFO, because currently the disputed land is in the DFO's possession.
Then what is wrong? But one thing I find it very difficult to appreciate here. Kindly see this impugned order. Why? There was earlier. Kindly come to page 44. Para 12. Since the learned trial court had no jurisdiction to decide the title over the disputed land, his order directing the officer in charge so and so to put Nipendra Chandra Das in possession over the disputed land is beyond his power. It is quite illegal and beyond his jurisdiction. Accordingly, the impugned order dated so and so stands set aside. So the order of attachment,
Yes.
the order of initiating proceedings under 145
Yes.
and 146 is gone.
Yes.
Now, kindly see, although the disputed land belongs to the forest department, it appears that the parties are fighting each other, claiming their right, title, and interest over the state land since long. The dispute requires to be ended between the parties, and thus considering the entire fact and circumstance, this court deems it proper and accordingly refers the matter to so and so for passing appropriate order as regards it. Till full inquiry and resultant decision is taken by the so and so in this regard, is directed that shall take the possession of it. How is this possible?
Yes, Lordship, there is a fallacy in this order, Lordship. A final order has been passed without any final relief, and perhaps
No,
yes,
when any revision is being filed before the authority, the revisional authority would at best set aside that order.
yes, Lordship. They
But-
have come up with
but-
additional direction.
but- How is it given? Additional direction also can be given to that extent in paragraph number 12.
Yes.
But how is 13 given?
In a short, Lordship, it is like a permanent injunction.
In fact, he has now not only taken, made the attachment, he has now handed over the possession
Yes.
to another authority. How can he do so?
Perhaps that is the reason why the petitioner thought of coming through the 226. Route.
We issue notice and stay this paragraph 13. Only paragraph 13.
Yes.
Remaining it is there, let it be there.
Lordship, I would suggest that I can take instructions from the DFO.
But this is how it is being given. How can you take over possession? The DFO was nowhere in the scene.
Because Lordship, the land is forest land. and-
Understood.
Yes.
You take it. You do whatever it is. That is a separate cause of action.
Yes.
You have a power, you can very well take it. But the fact is, how are you taking this? How a court can pass an order to the effect for you to take over?
Yes.
Till 13 it's okay, 12 is okay, but 13 is very difficult to digest.
Perhaps because Lordship, it is a forest land, and as such, there is no heritable right. And therefore, Lordship, even though that reasoning is absent here,
But that was
Yes.
not the subject matter before the authorities.
yes, that was not there. I'll take instructions, Lordship.
I think I do one day. I won't pass any order. Then the petitioner is not present. Let it go. This is the matter after the Bihu holiday. As the petitioner is not. Hmm.
My lord, in this case, my lord, I am the tenant under respondent number 5. And my lord, and I am paying rent regularly. And there are some disagreement arise between the with the respondent number 5. So matter, I filed the title.
Who is respondent number 5?
Respondent number 5 is the owner of the building.
Then
And thereafter, my lord, I am paying rent before the court. In the meantime, my lord, the electricity department removed the meter on the basis of the application of the respondent number 5. And I am in the dark, my lord. I approached before that, my lord, I approached before the ASCB,
no. First of all, there is a suit pending.
not pending.
Have you filed an application under section 5 and 6 of the that Assam temporarily set Assam Urban Area Rent Control Act?
Yes, my lord.
Take a suit. Have you filed it?
I am paying rent, my lord.
There. Have you filed under section 5 or 6? I think section 6 of the Assam Urban Area Rent Control Act for the purpose of restoration of the electricity.
Not under 5 and 6, but in MJ cases, my lord, I filed this. But
You are
not-
doing that is depositing of rent.
Yes.
Electricity has been disconnected. Obviously, you have to move under that provision.
But I have not filed it.
Go and file there. Assam Urban Area Rent Control Act. Isn't it?
But otherwise also, I do not want to dispute on a matter of such nature. There's a judgment of the Supreme Court which says, my lord, when it comes to a dispute between a landlord and a tenant, right to electricity perhaps cannot be used as a handle by any of the parties.
Understood. That I know.
But-
That judgment I know
Yes,
that.
yes,
But then also
There- there is a-
that
there
has
is
to
a-
be applied in that.
yes, there has
How
a-
can you file a writ?
There is an
Hey, come on. Assam Urban Area Rent Control Act. Second. That judgment came from a filing of those type of applications and an appeal and went to the Supreme Court,
Yes,
and that judgment was, I know the name of the judgment. You,
Dilip Dead.
Huh?
Dilip Dead.
Dilip Dead. Dilip Dead judgment, you take that help of that judgment and get your relief out there. I'll give you the citation. Wait.
It is, my lord, criminal appeal number 810 of
No, no, no,
2020.
Dilip Dead. 2022, write it down. 2022 SCC Online SC 810. There Justice Indra Banerjee has said, na?
Yes.
It is now well settled proposition of law that electricity is a basic amenity of which a rich person cannot be deprived. Electricity cannot be declined to a tenant on the ground of failure or refusal of heir to issue no objection certificate. All that the electricity supply authority is required to examine is whether the applicant for the electricity is in occupation of the premise. So have you got an injunction or anything?
No, my lord. Injunction was not, proper notice was issued.
And that is why you are asking for injunction.
Proper notice was issued, my lord.
Yeah, section 6.
And my lord, I filed representation earlier.
Hmm?
I filed representation before the before removing the meter, my that page 59, my lord. Page 61, my lord. My representation. Everything I have
You see, Mr. Chaudhary, kindly come to paragraph 8. Why he filed the suit. This is exactly for that electricity supply. Now, when he has not got an injunction, he has now come before this court.
Yes.
And you see the last 4 lines from paragraph above paragraph 8. The petitioner further submits that petitioner is staying in the first floor, and if the electrical line is disconnected, the water supply of the area will be disrupted. The area further submits that to fall the petitioner in distress, somebody stolen the tube well by removing at night, by which the petitioner filed an FIR. Then approached this court for this.
Yes, sir. So it is a prayer also before the lower court, ma'am. That page 38, my lord, will fight. Start from page 37.
And it is not you. You see, the meter, I think there is still electricity in the building,
No, my
in the entire building.
entire building meter is removed.
So what happens to the other tenants?
Other tenants also in this, other tenants are already gone. Now recently they're gone.
When?
Recently, my lord, they're gone. They are saying that they have no other way. They cannot fight with the owner. But I am fighting since last 6 months. My lord.
And when did you file the suit?
I have filed a suit, my lord.
In 2023.
Yes, my lord. Because he, my lord, sent advocate notice on 2/9/2023, my lord. I filed reply, my lord, on 29/2020. And my lord, totally misleading the facts, my lord. Before that, my lord, he certified, my lord, that I paid the rent. His certification, my lord, kindly see the page 23 and 24. He certified that on 8/9/12, I am paying rent. Thereafter, my lord, he sent.
No, I think, Mr. Counsel, you see, kindly come to page 55. This is your prayer. In this case, the trial court had issued notice.
In MJP.
MJ. So under such circumstances, either you have to file an application under section 6 of the Assam Urban Area Rent Control Act before the trial court, or file an appeal against this order.
What is my humble copy?
But how can this court
Despite
entertain a
existing all facts, my lord.
Huh?
Existing all facts, my lord. I approached before the, my lord, electricity department. Despite knowing this fact, my lord, the electricity department removed the meter. Everything know this fact. So is it not an arbitrary act of the FPDCL? Knowing this, everything, this fact, my lord, I have approached before the authority, highlighting all facts.
But when there is already a proceeding, would it be proper on the part of this court to pass an order?
My lord, I am seeking my lord, relief against the FPDCL's actions. The latter trial court may decide that is pending.
But your injunction application then will be decided by this court. Wouldn't it be?
At least, my lord, your lordship may direct mandamus against the FPDCL. At this stage, FPDCL, why everything is on record? Why you remove this meter? My 3 years or 6 years son, my lord, 7 years son who is studying in class 3, my lord. And the first scenario, my lord, for the last 1 week, my lord. I mean,
Mr. Chaudhary, you get your instruction as to whether you did it, whether there is a disconnection being done by APT. Can you get your instruction?
yes, my lord, this, I have
I'll get
annexed,
it,
my
my
lord. I have annexed
I
page
think-
64, my lord.
Friday.
Please the matter again on Friday.
My lord, on 11/12, my lord, I have some emergency.
What?
I have some medical emergency.
Not necessary. Ask somebody else to appear. If you want an order in your favor, then be remain. Wherever emergency.
On 12, my lord.
Please the matter on Friday.
Keep it.
Apply.
You get your instruction as to whether you did it.
Yes.
If you have done it, maybe at whatever, then I imply delete and direct it. Then you can get the relief. That is the only way.
Deeply obliged.
54.
Yes, what is this?
Yesterday, court made this order.
Huh?
The matter is raised with eviction from the government. There is some irregularities in the eviction notice. That's already decided by this. Yesterday, some order is passed.
Who has passed?
Court number 2.
Regarding not to vacate.
Eviction is not as per procedure.
Why?
Because there is a turn to page 35 eviction notice. There is no mention about the date and there is no procedure mentioned
provision they are fixing here.
Page 33.
Yes, your lordship. 30.
Uh,
And Arnicola 35. Three ground.
Then
You to notice a common notice. Set aside.
set aside.
Set aside. Because
Why?
ASO has no power here. Yes, sir. The
Who has no
assistant-
power?
Assistant settlement officer has issued this import notice, but that officer has no power. The deputy
The
commissioner,
settlement officer has no power,
assistant settlement, no power.
or the settlement officer has no power. The power has to be exercised by
Circular deputy
the
commissioner,
revenue
circular.
authority. Let us see as to whether power can be done or not. Let's see the settlement rule.
That order it is not done.
Hey, এখন নিদিব, এখন ভুল। Yes. The power as per section 3, rule 3, in respect of rule 18(1) and 82, may be made only to a subdivisional officer or to a circle officer or to a circle officer attached, not to an ASO.
Otherwise, that is the riverside land law. That is why I have talked
Roadside.
roadside. And there is some river areas also. there.
Understood. No, you are right
Look.
in issuing, but the only question is
Procedure.
that this has not been done.
Look.
All orders passed by supporting of the provision is to will subject to revision by the deputy. The settlement officer is 4,
Good.
and the ASO will be under him.
Good.
Isn't it? So this notice which have been issued is by the ASO.
Good.
So ASO has no power.
Good.
সহকারী বন্ধ and both the matters are same.
Same here. Three ground. Your status. There are 2 and 3.
Next to the same date notice.
Same date, common notice, only date, mentioned, but there is no memo number is not changed. Number of notices are here, but memo number also not changed. Same notice, same date.
Memo number is different.
No, same memo number, same date.
Name is just included.
Plus included name. But there is another
Heard
thing.
Mr. S. Islam, the learned counsel, is appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent number
2, 3, 4, 5.
2, 3, 4. Mr. B. Chaudhary appears on behalf of the respondent number 2, 3, and 6. No. 6 also?
Logistic.
2, 3, and 6. Mr. B. Goswami appears on behalf of the respondent number 5. And Mr. S. Dutta appears for the respondent on 1. This is in the same, in both, na?
Same.
Array of parties, the same. Why are you making the circle of the party here?
The circle officer also they present at the time of eviction, right? A few minutes I got information instead of submitting that order. They are demolishing the house of the respondent number 4. They started demolishing.
The circle officer is not, but the circle officer could have issued the note. He has not.
Whenever I got information, they submitted this order of 104. That house is demolished.
They are demolishing
Half an hour I have a call on the petitioner.
your case. In these
Yes,
writ-
yes, yes. 104. Yesterday's order.
without notice.
Without that, on the basis of that notice, they are demolished their house. So they started.
In these cases, have they started demolishing?
No.
They have, but this yesterday's case, 104 WPC, they have submitted the order. But they are saying that the government official have not implemented the order.
That I can't help you with that. But I will take care of it. Both the writ petitions are taken up for final disposal at the motion stage itself. Taking into account the challenge so made, it reveals from the records that the petitioners herein are aggrieved by the notices issued by the assistant settlement officer
But it's not. It's that.
bearing the same memo number in both the writ petitions. That is BJC 13 oblique 2020 oblique 1058 A dated 27/12/2023. Various aspects of the matter has been argued by the learned counsel for the petitioner. As regards the impugned notice. But amongst the many, one aspect which which this court finds is very pertinent is that the said notices have been issued by the assistant settlement officer Balijana Gwalpara. Balijana Revenue Circle, Gwalpara. The question therefore arises as to whether a notice under section 18.1 or 18.2 can be issued by the assistant settlement officer. More so when the settlement rules makes it very clear that either that notices under section 18(1) and 18(2) can be issued by either by the deputy commissioner or by the subdivisional officer or circle officer or circle officer attached. Full stop. If that be so, neither the settlement officer nor the assistant settlement officer have been empowered as per the settlement rules framed under the Assam Land and Revenue Regulation 1886 to issue such notice. Taking into account the above, as the notices have been issued by an authority which is not competent to do so, the impugned notices so far as issued against the petitioners in both the writ petitions bearing number BJC-13/2020/1058 dated 27/12/2023 are set aside and quashed. Full stop. This court, Mr. S. Islam, the learned counsel appearing on behalf of the petitioner, submits that the respondent authorities are taking steps on the basis of the said notice to evict the petitioners as the matter is being taken up. This court directs Mr. N. Goswami as well as Mr. S. Datta, the learned counsels appearing on behalf of the respondents, to immediately inform the respondent authorities not to take any action on the basis of the notices dated BLC-13/2020/1058 dated 27/12/2023 insofar as the petitioners. A copy of the instant order shall be also served upon Mr. N. Goswami and Mr. S. Datta during the course of the hearing, during the course of the day for effective compliance. This court, however, makes it clear that setting aside and quashing of the said notices dated BLJ-13/2020/1058 dated 27/12/2023 shall not preclude the respondent authorities to take such steps as per the provisions of law, and more particularly on the basis of, and more particularly by officials who are duly authorized to do so. Mr. Barbudari, only one thing, you were not there that day. I think you were in bereavement. That matter I heard, the jail matter.
Yeah.
I've looked into the matter, the papers. I, in fact, drafted out from the facts out there. Then I found that the facts were very disturbing. So I have asked Mr. Didas on that day.
I have been informed. Yes.
Yes, so that I have asked him that these are the facts you need to clarify. So I'm having it tomorrow
Yes.
as the first item of the day.
Absolutely, my lord.
Kindly be prepared.
Yes, yes, my lord. I'm obliged.
Mr. Goswami, kindly inform your DC. Yeah? Later on, after this, if it is done, then the contempt will be initiated.
Steps have been taken.
Huh?
Steps have been taken.
Infractions?
Not infractions. Steps have been taken.
Okay, no steps. The learned counsel appearing on behalf of the petitioner submits that the steps have been duly taken. When?
Yesterday, on 9.
Steps have been duly taken on
9/1.
9/1/2024. So taking into account the above, the registry shall list the matter after completion of the steps completion of the service upon the respondent number 2 and 3. Full stop. If it is, however, however, on verification, if it is found that the matter has not, no steps have been taken, then the matter be again listed before this court for further orders on 22nd of January. No steps.
We have taken steps today.
When?
Today.
Ms. So the learned counsel appearing on behalf of the petitioner submits that the steps have been taken today upon the respondent number 3 and 4. Today.
Yes.
3 and 4.
Lordship, all the response.
On all the respondents. Also taking into account the above the instant petition be listed after completion of the steps. Service upon the all respondents. It is, however, made clear that in the eventuality, if it is found that the yes.
But if that GMC matter on 18th, 10th, there is an order.
Yes, what is the present progress?
Lordship, the amount, requisition amount, Lordship, the director medical education has referred it to the finance department.
Oh, that medical matter.
Yes.
You are there.
Yes.
The councils fighting amongst themselves. Yes. Who is they going to appear for? Yes. What is this?
Firstly, my lord, the requisition amount of rupees 9,91,000 and all. The director of medical education.
No. I am not on those. I am on the question of the acquisition. What
It is
acquisition?
there, my lord, the second paragraph. Sorry.
Yeah.
Further, with respect to the place acquisition proposal.
Where
it is
some
stated-
rectification was needed. After going to the rectification, finally the proposal has been received. The proposal will verify the action will be taken for submission. This was on 18/11. We are in December.
My lord.
Then
1811, it was.
we are in
forwarded to-
January. What is the
After
updated?
that- After that. there is no-
Okay, you'll have it on 18th, 19th. This is the matter again on 19th, on which date Mr. P.J. Talukdar, the learned counsel, appearing on behalf of the revenue or the DC?
DC.
DC Kamrup Metropolitan shall apprise this court about the present status of the acquisition proceedings.
Right.
Full stop. Further to that, this court also would be. Have you got the 9 lakhs? Further to that, as the learned court, this court shall also be intimated as to when the amount of rupees 9,91,374.82 could be released to the petitioner. Have been released, or as to when, as to whether the amount of rupees so and so had been released to the petitioner, and if not, when it would be released.
Okay.
As far as releasing of that amount, Lordship will kindly direct the standing council health department because they are moving the matter.
Of health.
Yes, yes.
No, there is the recording that they have already paid the money to them. The DME says that they have already paid. I've recorded in my order.
So DME has now moved a proposal to the government in the
No,
health
this is for the acquisition.
For acquisition.
No, this is, I'm saying about the requisition.
Yes,
This
requisition.
court further directs that in the meantime, the amount which have been deposited by the Director of Medical Education be disbursed to the petitioner persons entitled to, including the petitioners, which is the requisition rent from 1/5 to 30/10/2021. The amount has been deposited. When it will be paid to these people?
No, but this instruction which Lordship has does not think
my lord, this 22/11/2023.
Hmm.
Their lordship will kindly come to the second page.
Hmm.
Second page, my lord, this is a communication from the Director of Medical Education to the Additional Secretary, Medical Education and Research Department.
Hmm.
Lordship, kindly see, my lord, the amount is 9,91,375.
Hmm.
This is the requisition rent, my lord.
Hmm.
Now, this is required to be disbursed. Here, my lord, the proposal has been moved to, my lord, the government in the Medical Education Department. In turn, now they will move the Finance Department seeking an FOC. And if required, my lord, a supplementary demand, my lord, will have to be made. And earmark has to be made. Now the budget session is, my lord, it is ensuing. So lordship, to that extent, lordship will direct the sending council health people. That is my submission.
For what?
My lord, to know the status of this amount.
No, on the earlier occasion, they have categorically mentioned this. The requiring department, the director of health, you see, assistant is who has written on the earlier assistant deputy commissioner Kamrup Metropolitan. The requiring department, that is director of health, had already been requested to deposit the requisition amount amounting to so and so,
Yes.
followed by the rent shall be paid as soon as it is received.
Yes. Now that amount has to be, my lord, practically been disbursed to the petitioner.
And the health department is a party.
Yes.
Oh, health department is not represented. Yes, why you are not paying the amount? You tell of your instruments. You don't have money.
I'll get the inspection
They are
because they have
moving, my
moved.
lord.
It is
being
under
done. It is being done, my lord. They are moving. It is not.
No,
they are
there's no
being done.
moving. You see, this is for 5-7 years. What is this type of moving? Because of this court having caught hold of you, then you are moving. Otherwise, you are completely silent.
No, my lord, now things are
Our
moving.
lordship,
Lordship will see
it
a
is a
You have
seven-
some instrument, give it to them.
Lord, I'll get the status.
Get me an instrument. You ensure the payment is made to them
Yes.
by 19.
Yes, Lord.
The health department shall also ensure the Tarago So as regards the amount of rupees 9,91,374.82 paisa, the health department shall ensure that the said amount is deposited with the district administration for onward dispersal to the petitioner on or before the next date.
There are here also be calculated.
Madam, I'm getting you the acquisition. Let us see.
Now acquisition. Now the rent will be paid. Now the authorities will move for acquisition. And acquisition, my lord, 1964 Act, but the quantum will be as per the 2000.
Understood, but you were not thinking about that. It is I who have held it that you need to do it.
Therefore, my lord, with all respect,
Nobody
my
was
lord,
arguing on
my
that.
lord.
Yes.
Okay.
Obliged.
Hmm.
This case, your lordship, the petitioner was initially granted some compensation.
Who has filed it? The petitioner will be at liberty to file a reply. Reply, are you filing? Not required. Okay, very good. Affidavit in opposition filed on 20/12/2023. What is the matter about?
Matter is that your lordship, initially they were granted compensation on a very low rate. Thereafter, they made an application before the competent authority.
To fresh assessment of compensation in terms with the provision and to pay the amount. Who is going to do this?
This has to be done by the competent authority, which is the
Why? Award has been passed.
Yes.
Then how can this court direct them to again? You are to file under 3GF5.
no, your lordship. Since the award has already been passed, your lordship, and they are not acting upon the award, your lordship.
Then?
Then your lordship, they have filed an affidavit. Lordship will kindly see at page 44, starting page 45.
No, competent authority, the arbitrator has given something.
Yes, yes, has passed an award.
And then
And then nothing is.
they are not.
Then the estimate has been prepared, revised estimate. Subsequently, they have released some award. In the meantime, we will pay in the meantime.
When?
Page
That's 45 para
Let us
6.
see, then back to state that an amount of year was initially sanctioned by the governor for the purpose of What is this portion of the award? What is this business of portion of the award? Yes, Mr. NHI.
No, we do not have. Road is not being constructed, I think. PWNH division.
Huh?
Road is not right.
You are not. Why the government of India is paying?
Because NH division,
Is it funded by the government of India?
yes, NH division, but PWD NH division.
It's funded by the
Private.
central government.
Yeah, because we have also PWD NH division also. It is also under government.
Now who pays?
Huh?
Who pays this amount?
It will be paid by NH division, that was the requiring party.
NH division?
At PWD, National Highway Division is there. Yeah. It is that they will be paid. Because NHA is not requiring party.
No, here they say that the government of India had sanctioned 14.59 was initially sanctioned by the government for the purpose of acquisition of.
To this particular requiring agency PWD NH division as the constructing agency.
Then who is going to pay for the?
Then NH division, PWD NH.
But why the government has paid? Government of India has paid for.
Because it is the NH division is conducted under government of India. Government of India. Because NHA detail, NH division, and NHA.
So Union of India is the main person.
Here, PW NH division can reply on this point. They are appearing on it.
Are they made parties?
Yes.
None is representing.
They are
We
reply
have
on
the
this
chief
point.
engineers present with the garland. When a matter has been called for, the the PWD department is not represented. This court, upon taking into account the affidavit which has been filed by the deputy commissioner, filed by the additional district commissioner, Hailakandi, finds it pertinent to note that only a portion of an amount as directed by the arbitrator has been sanctioned by the requiring department. And till date, no payment has been made. So, taking into account the above, this court fixes the matter on 29th of January 2024, on which date the district commissioner Hailakandi shall apprise this court as to whether counsel appearing on behalf of the district commissioner Hailakandi shall apprise this court as to whether the portion of money which have been received have been duly disbursed to the persons concerned, to the beneficiary. Further to that, this court directs the PWD department to apprise this court as to when the entire amount would be sanctioned. This court also duly takes note of that the PWD is not being represented by the council, and as such, on the next date, if the PWD counsel for the PWD is not appearing, the chief engineer PWD shall be present, NH work shall be present in person through video link to be provided by the registrar.
PW NH division particularly.
NH works I mentioned.
NH.
Chief engineer
NH.
PWD NH work shall be present in person through video link to be provided by you. You can provide no, but shall be through video link.
Apply.
Director not to finance activity. The then we have paid this
Huh?
they have not yet approached us.
No, they have not. This court has been insisting upon you from 9/11.
Yes,
Then,
we have
then
overtaken.
if they are
They have
not
instructed-
interested, why should I? I should dismiss this petition as
You want to
non-prosecution.
pay, I have instructed him overtaken 2-3 times. Thereafter, I have.
They,
given a
I think they have
written-
not paid. That is why they don't know.
Yes, maybe. But
This is a cancellation. That is why I put the question as because this was cancelled in the year 1972, and for which I wanted to know that if she has known.
Dear Lord, I have tried my best and already.
You
I
are
have
the representing counsel.
engaged.
Very engaged. Miss, the instant writ petition has been filed. Seeking a direction upon the respondent authority to accept the revenue of the land measuring 8 bighas, 2 katha, 3 acres covered by DAG number 172 new, 243 old, patta number 9 new, 10 old, Moza Kachmari under Nagaon Sodor Revenue Circle in the district of Nagaon, Assam. It reveals from a perusal of the materials on record that on the basis of an order passed by number AK number 42/71-72 and the DC's office memo number 14447-48 dated 11/7/1972. The land measuring 8 bighas, 2 katha, 3 acres pertaining to DAG number 283 was made government khas land. It is under such circumstances this court, taking into account that the writ petition was filed in the year 2018, directed the writ petitioner to produce any documents to show as to till when the petitioner have paid the revenue to accordingly. Various opportunities was given to the petitioner, but the petitioner have not been able to produce any such documents. This conduct on the part of the petitioner not only shows that the petitioner is not interested in the present proceedings, but also the filing of the instant writ petitions grossly suffers from laches. Accordingly, this court finds no reason for issuance of a writ in the instant proceeding, for which, and accordingly, the instant writ petition stands dismissed.
I do object.
Yes, madam.
But we have
The last
received
order,
instruction.
1710, my lord, they were supposed to file an affidavit.
My lord, affidavit they could not file, my lord, but we have received the instruction, my lord. If your lordship grant time, my lord, I have filed affidavit. My lord, we have received the instruction, madam.
Ms. Yudas, Mrs. Yudas, the learned additional senior government advocate submits that district commissioner,
My lord,
Huh?
my lord, from circle officer, I have received the instruction.
that appropriate instructions have been received from the respondent numbers 3 and 4 and would like to put the same by way of an affidavit. So taking into account the above, list the matter again on 5th of February 2024. In the meantime, the affidavit be filed by 31st of January.
Here to not often file an affidavit to lordship today, and I was served a copy you wrote 1 hour back. Later maybe take out some other.
Mr. S. Bottaku, the learned counsel appearing on behalf of the petitioner submits that the government has filed an affidavit. Government means who?
This is the circle officer, your lordship.
Huh?
Respondent number 3.
The respondent number 8.
Respondent number 4, your lordship.
The respondent number 4 has filed an affidavit in the matter today. Has filed an affidavit, submits that an affidavit of the respondent number, a copy of the affidavit of the respondent number 4 has been served upon him today. Mrs. Yudas, the learned additional senior government advocate, submits that the affidavit would be filed,
Mm.
is in the process of being filed today.
Well.
Taking into account the above, list the matter again on 12th of February 2024. In the meantime, the registry shall bring on record the affidavit if so filed, and the petitioner in the meantime would also be at liberty to file the reply if any.
Safety of that. For 1926, in the next day, we plus 27.
Which one?
Earlier, I think. I'll not be here.
Huh?
I'll not be here in 26.
What is this 26? What matter was that?
Next matter, but the next date was fixed on 26th of February. Can it be on 27th?
5.
Oh,
5th of.
sorry.
Hmm.
Maybe. Yes, there were actually two petitions.
Huh?
Actually, two petitions are there. The petitioner number 2 has got to withdraw from the
Petition number 2 has withdrawn. Oh, then?
other petitioner.
So you don't have too much of support. What are you challenging?
We're challenging the process of initiation of a the granting of license of a wine shop.
Where?
At Hawaja.
Awajan. Why?
The count of grounds are that the place of proposed the site is within the prohibited range.
How do you say so?
That was our not now, but they have filed a come up with an affidavit that is within the prohibited range. So the other leg of argument, there are some complaints filed by the local public before the
Why the local public is not before this court? Why you are there?
there are representatives filed before that.
So you are ventilating the grievances of the local public? Yes.
Earlier there were 2 petitions.
Huh?
Now
You fear that you will be sent to court number 2? On appeal or PL? Which one? Tell me, yes. So many affidavits filed. So the grievances, everything. Now, whether it was a new allotment?
new alert.
So new allotment and it is being given in some place.
Some.
So you have filed objection.
The local public have filed.
Have you filed objection?
Yes.
Why the local public is not before this court? Other people? You had the support of one more. He has also left.
Yeah.
So you are the only tiger out there in the boat.
So, my lord, I took some time, my lord, to take a
To gather some
guidelines,
more.
whether like but
They will like to proceed with it.
Yeah. some time maybe done.
There is an interim stay against my license for the last more than 3 years. Lordship should kindly notice that the petitioner number 2, now he is informing the court that the petitioner number 2 wants to withdraw. Only after I, in my affidavit in opposition, pointed out that the petitioner number 2 has filed an FIR to the effect that a rival license holder, a rival wine shop owner, has pressurized him and threatened him, and he does not even know. Petitioner number 2 has stated in the FIR, subsequent to which a charge sheet has been filed, as per my instruction, that he does not even know who is the advocate representing him in this high court. All these things have come to light, and he now wants to withdraw for the petition number 2 only after my affidavit in opposition has been filed. And there is no specific denial to all of these allegations that I have made in my affidavit in opposition.
Let it be on Friday, my lord. Okay.
So there is no stay. Is there any stay?
Yes,
No stay.
No stay, my lord, only 3.
there is a stay, initially stay of the past.
Oh, till the next date.
Yes.
On is what? Bar.
Yes,
On his
on the site.
Yes, what is your step?
Lordship, we have conducted an inquiry about it.
And
An inquiry, we have filed an affidavit.
where are you going to have it? Let us see the place. Hawazan, where is it?
The location
Where is Hawazan?
Hawazan Gopur subdivision.
Gopur.
Gopur.
Well,
And affidavit in opposition, we have filed.
Hawazan Gopur subdivision. He wants to open a bar. Now, who is the petitioner? Let's see. In these cases, resident of Hawazan, post office Hawazan. And where is he? Where is the proposed license? Means you are to be given where?
In Hawazan.
Hawazan is such a small area.
Yes,
How big?
Not a very big area. Not a very big area, and
What is the population?
population is around 6,000. There are 2 existing shops, and petition number 1, as per my instruction and as per the specific statement that we have made in the affidavit, used to be an employee of a rival shop owner. And petition number 2 used to be, a customer of that shop. This is all a got up litigation. This is all this completely sponsored litigation. For more than 3 years, my lord, we are being harassed.
Okay, we'll have it on Friday.
Right.
And just if you are not able to satisfy this court, then exemplary cost will be imposed. Okay. Because somebody's right, you have stopped it. Now the cost will be commensurate with for how since when the stay has been granted.
2020.
For last 4 years, the loss, how much you calculate? You have already made your infrastructure.
Yes,
Yeah,
deposited
yes.
license fees
We
also,
have
Lord.
deposited the license fees, and some part of the work was done. At that point of time, they came up with this.
So infrastructure has been done.
I
So there
definitely
will be
specific
escalation on making that.
on that.
So
Lordship, I
these
definitely-
aspects you find out will impose the cost if it doesn't satisfy the locus. List the matter again on Friday. Further consideration.
Oblige.
This is regarding item 10. If, I pray for liberty to be granted in case other remains.
Miss Gail, you tomorrow, that matter I fixed it now, the
Yes.
ED matter.
Yes.
Keep the file because because of
Yes,
that file being not there, again, something may crop in and I may not be able to dispose it
sir.
of.
Yes.
So you ask your officials to get the file.
Yes, ma'am.
Yes, what is this?
If I withdrew the petition to file a representation.
Oh, that one.
My
You can file the job. Oh, yes.
lord, liberty may be granted to approach the court again if the need.
I said that you, without prejudice, you can file your representation. then why is it necessary liberty? Then if your representation is rejected, wouldn't that be a separate cause of action?
I
My lord,
Yes.
in this case, kindly accommodate me for a week, my lord.
Why?
My lord, I'll place the instruction, my lord, and immediately after the vacation.
Okay.
Accommodate on for a week.
You want to file?
No,
Reply.
no, instruction, madam, last order was there.
Again, for all respondents have sought further time to obtain instructions as to
Exactly.
whether the
That is the-
matter of restriction on construction activity provided earlier in the guidelines of later on revising the and finally as on the advisory construction area. Miss A. Gayandalan, counsel appearing on behalf of the
1, 2, 3.
respondents,
1,
number 1, 2, 3, 6 for an further accommodation to obtain the instructions. This is the matter again on 5th of February 2023, 24. First up, it is made clear that that Ms. Agayan shall obtain the instructions without any fail,
Yes, has subject.
without any doubt.
In this matter, no affidavit has yet been filed as per the order of the.
Affidavit file?
Not file. My lord, we have received instruction, my lord. I may be allowed some time to file affidavit, my lord, or my lord.
In applicant put the appropriate authority.
Yes,
My lord, we have received the instruction, my lord. Please to peruse, my lord.
but you were supposed to file the affidavit.
My lord, my lord.
So this is a serious breach committed
lord.
by the authorities. This is not a case of anything else. This is a case of explanation to be given. An explanation when it is called from the respondent authorities, and if the respondent authority does not give an explanation, I can't act on these type of things. This is a very serious breach by the district commissioner, Kachar. I think this is a fit case that he should be heard in person. Why should I look into all these things? What did he say?
Short time maybe, my lord. Depend, my lord. We did
Short
so that
time.
we get
Okay.
short time,
18.
my lord. Maybe,
18.
maybe. my lord.
Today. Oh, today is 12.
Well,
11. Today is 10.
My lord.
Oh, 18 is too long.
My lord.
12th.
Vacation. Puja vacation. Sorry, new vacation is there, my lord.
12th.
From 13 to.
No, this is a very serious thing. There is a direction passed by this court to
Lordship.
complete it within a period of 6 months.
My lord.
That was done in the year 2017.
Lordship.
6 years have passed by. Now it is 7.
Then maybe on 18.
I congratulate. Ms. Yuda submits that the records, the instructions have been duly received and would file the affidavit. List the matter. I'm fixing it on 22nd. 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 List the matter again on 22nd. The affidavit be filed without fail by on or before the next.
Lordship. Deeply.
Yes.
My lord, we have challenged 2 notices. In respect of, my lord, demolition on account of a lack of NOC, my lord, we'd like to approach the authority. My lord, we'll approach them for regularization. They will take a call. But on the second aspect, my point is, my lord, under 88(1), a notice is required, which was not. If a lordship will kindly come to that, It's an admitted position, my lord, that NOC was not taken and some temporary construction. These are not, I mean, permanent construction. And therefore,
Permanent
my
construction is, I have constructed one Assam type down. Permanent. And that too you say,
what are the nature of construction? I mean, of course, use is permanent.
if you see that the act as well as the various other acts, even a certain construction with Tauzi, yeah,
Tawzil,
no, there is not Tauzi land.
Torja,
Tauza, there is also brought within the ambit of a
permanent
construction.
construction. Now, my lord, but there is a larger issue in this.
Larger issue is not there in your case. In this, the
No,
case is,
no, yes, as far as the second notice is concerned, it is there. That is something which I'd like to highlight.
yes.
Now, first, let me place that second notice, my lord, that your lordship will get at page number 16.
Yes.
Not notice, it's an order.
Yes.
Whereas I, Sri Anurag Singh, Chief Executive Officer, GMDA, pass this order as per power conferred to this authority under Section 88 of GMDA Act, direct Messrs. Normata Agencies, so and so, to for removal of constructed Assam type godown in a plot located within eco-sensitive zone of Guwahati Master Plan without any valid permission from any authority. Whereas show cause notice was issued to you by dated so and so, this is regarding, my lord, unauthorized construction, which is examined and it is found not to be acceptable in view of the unauthorized construction of Assam type godown within eco-sensitive zone as earmarked in master plan in force, and therefore the same is rejected. Therefore, I do hereby direct Normata Agency also to vacate and demolish the completed portion of the Assam type godown, etc., within 5 days from the date of receipt of this order, failing which GMDA will be free to proceed with demolition. So basically, this is an order that because I have made a construction within eco-sensitive zone, therefore this is the order.
No, the order is without a valid permission.
But no, my lord.
Yes.
Within eco-sensitive zone.
Without any valid permission.
No, there, my lord will kindly have GMD Act for a moment, Section 88(1).
Second. Yes.
My lord, it's a long section, my lord. I'll draw your lordship's kind attention to last 3 sentences of subsection 1.
Yeah.
Provided that no such order shall be made unless owner, occupier, manager, or the person concerned has been given a reasonable opportunity to show cause why the order shall not be. So, my lord, no show cause notice was given. In fact, this was our case. On this point only, my lord, this writ petition was entered. On the first point, my lord, so certainly. Now, my lord, please come to para 30.
No, kindly come to annexure 1.
Yes.
As to why the approved area should not be demolished under section 88(1).
No, regarding this, my lord, what
Yes.
I'm submitting, my lord, it's a fact, my lord. My construction was without permission.
No.
Yes.
This annexure 1 is also a notice under 88(1).
Whereas you have undertaken, carried out development of building of land within GMDA area covered by so without requisite approval of GMDA, well, they are harping basically on without permission.
Yes.
That is one aspect.
Yes.
And to make a construction in eco-sensitive zone is another. Their notice was not to the extent that how come you are making construction in a eco. That is not their case. I'm on that matter. They say without requisite approval.
But then also, this
No, my
is
lord,
with
my lord,
you have contravened 24 and 25.
My lord will kindly appreciate. Even if I get approval, I cannot make construction in eco-sensitive zone.
So therefore,
So therefore,
25.
question of giving. So therefore, if they want to invoke 88 of the ground,
Yeah.
that my construction is in eco-sensitive zone, then they are supposed to give me a notice in terms of the provision, which they have not given.
88 is for demolition.
Before demolition, I am entitled to a notice.
So here it has been mentioned out here in this very notice itself. Now, therefore, you are directed under so and so to stop to so called as under so and so under
my
10
lord.
days of receiving
this
notice as
certain
to why
notice.
approval should
It
not be
was a-
demolished.
It is a notice under 87, not under 80.
Understood. Mayor, wrong quoting out there of the section would not, because this section 87 does not conceive of a notice. It
No,
only
my
says
time, my lord, there are
direction.
two aspects. They can proceed against me on two counts. One, construction is without any NOC or there is no approval. Secondly, construction is in eco-sensitive. As far as the first point is concerned, my humble submission is will approach the authority will take action. But regarding that my construction is in eco-sensitive zone, that in my humble submission is not correct. Because my lord, I am entitled to a notice in terms of the proviso, which they have not.
Let us not go into the eco-sensitive zone for this matter. Let us see as to whether, because it is an admitted fact that you have constructed without the permission.
That case, to that extent, my lord, I'll approach the authority will take a call. To that extent, even I am not making any argument on. Now, my lord, I spoke about a larger issue. Please come to para. Please allow me to read 2-3 paragraphs, my lord, 13 to 16. How things are happening, my lord. Just one page on. Page 8.
Yeah.
Or lordship may, yes, para 13. Having regard to the aforesaid settled principle, what logically follows is that an authority, while attempting to prevent unplanned haphazard development by a master plan during regulation, cannot close his eyes as has been done in the instant case. Evidently, constitutional as well as mandate flowing from GMDAC have not been followed. As explained herein above, institutions like Royal Global School, Delhi Public School, Gurukul Sanskriti School, DTO Office Kamrup, commercial buildings like so-and-so were allowed to be constructed on southern part of NH 37 between Borsuk intersection and Lokra intersection. Prior to coming into force of the present master and zoning regulation with effect from 7709, the aforesaid area was covered by green belt. Would GMDA authority explain as to under what circumstances construction activities were permitted? Further, would the GMDA authority explain to this honorable court the reason behind altering the green belt area from Gorsuk intersection and beyond? That the petitioner, without prejudice to the above contention, humbly begs to state that area from Gorsuk intersection to Tetelia of NH 37 under Jalukbari Mouza, which also includes Poob and Paschim Boragaon, were traditionally inhabited by Ghosh Rajbangshi and other indigenous tribe of Assam. On the northern side of the NH 37, the said indigenous people used to reside, and on the southern side, they used to cultivate. Pertinently, the revenue record, these portions of the land are described as Titiya Basti, meaning they are residential land. The area of the land on southern side of NH 37, falling between Gorsuk intersection to Lokra intersection, was green belt area prior to 7709, that is coming into force of the present master planning and zoning regulation. Therefore, it is not understood under what circumstances GMJ permitted institutions like all these institutions, my lord. It was a green belt, they permitted. Now to save them, my lord, now it has been shifted. Now, my lord will kindly come to this third sentence. The petitioner therefore has reasons to believe the respondent authorities for extraneous consideration and to provide protection to this powerful and rich institution have shifted the green belt toward Tetelia in the Impune master plan for Guwahati area, that is 25. The said action being highly discriminatory, illegal, etc.
But Mr. Chaudhary, at the time prior to preparation of the master plan,
Yes.
there was a drafted notification issued.
Yes, yes.
Did you submit your representation?
No, my lord. What I'm trying to say is, my lord, how far I will be justified in maintaining this challenge, that is an aspect Lordship will certainly look into it. But what I'm trying to say, my lord, you have permitted these institutions to come up in green belt. Now you want to evict me on the ground that I have made construction in eco-sensitive. That is also eco-sensitive. Now to save them, my lord, the green belt has been shifted from that area to beyond. I am on that.
Yes.
Kindly see the propriety and the, my lord, bona fide of the action of the authority. End of the day, my lord, it's a public law remedy. The issue is before your lordship. So question is, when it comes to some petty person, then you stick to law. But when it comes to big people,
When
then
did you purchase the land?
one second. My lord, in 2003. 15/12/2003.
So under such,
By registered sale deed, my lord, after
understood.
obtaining permission.
So why didn't you file objection to that? If it was a made eco-sensitive out there, you should have filed
No, we
objection.
filed, my lord.
You have filed objection.
Yes, we have filed. Not only me, my lord, lot of people.
Now we are concerned.
A lot of people are involved.
Where is your statement that you filed in your petition?
Yes. One second. Now, my lord, that, my lord, clearly it is not there, but as far as I remember, my lord, I think it was told. And moreover, my lord, in paragraph 16, I have stated, now in the eco-sensitive zone, they have para 16, they have allowed all these institutions, my lord. This hotel, Radisson Blue and all has come up there. Even after sitting all.
No, they have, the government have taken a decision to do it in this manner. Now, isn't it the policy decision of the government to do that?
It's a policy. I appreciate everything. All that I'm trying to show is, my lord. When it comes to, my lord, general people, you are administering your law, I mean, strictly. But when it comes to some powerful lobby, my lord, you are shifting the goalpost. Today it is here, tomorrow it is there, my lord. So what I pray, my lord, we'll make our representation before the authority. Let the authority decide. Till then, the interim order may be maintained. Or will take all these
In
grievances.
this case, your facts are that you can be very well segregated. You have no permission.
That's why I
Forget,
said, my
no,
lord, at the
forget
very
about other eco-sensitive or
At
not.
the very beginning, I submitted, my lord, as far as the notice for not obtaining NOC, I am not even pressing into service. All the time pressing into service is the order.
You
issued
can
under
very
18.
well, no, you can very well represent on the question of the changing this thing, which the authority may take a call on that. The GMD authorities will take a call. That is a different thing. This is not for this court to decide on that. You may very well take a decision. I may give you a liberty. You can very well do that.
My lord, all that
But as regards interference with the order passed by the GMDA and the 88, the question doesn't arise
all
because
that I am saying is, my lord, because of all this background, will represent to the GMD authority. Lordship will give a time frame. Within 10 days from today, we will file. Next 10 days, they will decide. Till then, my lord, they will maintain setup. Only that one point. And it's a, my lord, construction, and we are not going to run away from anywhere. And in my lord, in between, there was a proposal to waive these also, my. Now, of course, they filed an additional affidavit saying that is withdrawn. That eco-sensitive zone, they wanted to withdraw. Those aspects were all. That's why, my lord, the matter got delayed. Otherwise, it was in the hearing list quite 2-3 years, just before, my lord, COVID, I think.
eco-sensitive zone. Mr. What you call it? Mr. Nayak, where is this particular out here, the eco-sensitive zone? You have given a map here, huh?
Yes, sir.
Where is the petitioner's land? Your land is where?
My lord, we are in
Moja, Lord.
Jalubari.
Yes, sir.
Jalubari Moja no.
we have described the, my lord, in schedule.
Pub Boragaon. Pub Boragaon.
Boragaon.
Pub Boragaon is where? Pub Boragaon, Pub Pochim Boragaon, Pub Boragaon. Pub Boragaon is this.
Boragaon.
Pupwaragaon is what you call, this could be other areas,
Near NH 37 Lord.
other areas.
In fact, my lord, that
In the
notification-
same area, in the same, if I'm not wrong, in the same area you are having the Science Technology Assam
Yes,
Wearing
yes.
House Corporation.
Yes, in my affidavit, Lordship will find some clarification. In WPC number.
Yes, this affidavit.
My lord, they have Institute of Management, Assam Science and Technology, Arcade Office, then Warehousing Corporation, godown for Tata, Hotel Radisson Blue, petrol pump, etc. A so-called, my lord, sensitive zone. In WPC number 2746.
That is what I'm looking at.
And the garbage dumping site was also in that lane. Lordship, one clarification, Lordship, I would like to give first. Lordship, the petitioner, if it is Narmada, Lordship, then it was purchased in the year 2013, not in 2003. That is subsequent to coming into effect of the 2009.
Why, how do you see that?
Lordship, from the record, Lord.
Show me that.
It says by registration, sale deed number 10443/2003, executed in 2015, 12, 2003. 15, 12, 3. 2013.
13 or 3? It is 15, 12, 2003.
It's a statement, Lord. No, my lord, 10443 of 2003. In that case, that also should have been 2000. Yes, Lord, it's 2003. I'm sorry.
Is it 13?
13, no, 3, Lord.
It is 3.
But Lordship, so far as other organizations are concerned, Lordship,
Hmm.
in that affidavit, Lordship, paragraph 14, Lordship will find the clarification. Lordship. Gurukul School, Royal Global School, Delhi Public School, GTO Office, Spectrum Honda, JCB India, Vinod Nissan, Hotel Barbara.
You have given a clarification. Gurukul is in Guwahati, is not within Guwahati Master Plan area. Royal Global is situated in village Betkuchi.
Beltola Moja.
Delhi Public School is in village Betkuchi. DTO office is in village Betkuchi. Spectrum Honda is in village Betkuchi. JCB is in village Betkuchi. Nissan is in village Betkuchi. Grand is in village Betkuchi. He is in Pupwaragaon.
Yes.
Now Pupwaragaon is an eco-friendly.
Eco-sensitive.
But there you are having Tata Godown.
Yes. Lordship, these are subsequent, Lordship. So far as these organizations are concerned, Lordship, I have to take instruction.
No, you
But
haven't
in the
yourself given.
petition, these names are there in the petition, so we have given the clarification. So if there are 16, those names are also there.
Now you have given this Annexure C. See, you have this Annexure C.
In the petition,
There you have given it. Assam Institute of Science and Technology. Science and Technology, it's a big thing. Assam Warehousing, that is in Paschim Boragaon. This area is in Paschim Boragaon, but Paschim Boragaon and Pub Boragaon are both put in the eco-sensitive, eco-friendly zone. Now, what happens out there in the eco-sensitive, eco-friendly zone? Are you not allowed to construct?
No.
Yes. No, you can construct.
Yes. One.
You can construct, but I think the
Lordship,
AI is 30%.
In this table, Lordship, what are permissible?
Yes, 30%. And if I'm not wrong, it is 30% if you
Yes.
see it.
Sorry, Lordship, there this residential dwelling low income group, that is permissible. Residential dwelling low income group, permissible. Then Lordship, nursery, horticulture and orchard, that is permissible. Existing villages are there. Fish curing, flood control work, these are permissible law. Bird sanctuary.
No, there is no bar
Yes.
in construction in the eco-sensitive. There's no bar. But the only thing is that you are given a reduced FR.
No, not it, what are permissible to construct, that
To me,
table
that,
is there.
yes, if I remember, once I looked into this book.
The column, 1E is marked on. Same table, Lord, from the first page. Lord, will get one column E.
Eco-sensitive.
Yeah.
Eco-sensitive is SP. Oh, no. E.
Just E. I think it's
Bird
second or third column
sanctuary,
from the last.
children's existing village, fish curing, flood control work, forest, golf course, integrated township. Integrated township is permissible.
That is permissible, but to start, I mean, the floor height will be
Limited
limited.
FAR, my
limited.
lord.
Motel is
Maharaj,
municipal facility is listed in Annex C.
Pollutant activity.
Nursery, horticulture,
Dwelling house is also permissible.
residential dwelling, low income group process are available. Yes, right. To the maximum of 30% of the FR is allowed.
If FAR is 100, then up to 30.
The following activities shall be permitted in the eco-sensitive zone and not in eco-sensitive, eco-friendly zone. Now he falls here in, this is in eco-friendly, na? Or eco-sensitive?
Sensitive.
No. What is this area?
Uparaga.
Uburagaon, is it eco-friendly or eco-sensitive?
Eco-sensitive. Uparaga, Paschim Baraga.
Now here you have mentioned in this
No,
document,
in the table,
Huh?
in the book, Lord.
it's given?
Yeah.
Where?
Lot if one lot will get one group there, lot if A, B, C, D, E.
Application.
Okay.
Use zone. E पता कौन सा
Uparaga.
Earlier this area was green belt.
Yes.
Hmm?
Earlier, that status I have to take.
No, that is already there in the repetition. They have specifically stated in paragraph 13,
Yes,
14.
they have statement.
You have applied.
I got
And how do you say that it is eco-sensitive and not eco-friendly?
a lot
So
of
it from here.
come to page. Itu master plan, eco-plan itu E12.
Because nowhere it has been shown as any distinguishing. See, eco-sensitive, eco-friendly zone. There you have within you hill, reserve forest, river, bill, nala. Till there it's okay. It may fall in eco-sensitive. Now this area falls in other areas. Why you are saying these areas to be eco-sensitive and not eco-friendly? Because the master plan does not show to that effect.
এতিয়া definition আছে সেইটো ওপৰে I think that the term of this master plan is otherwise over. The one which your lordship is
It is land using zone plan 2025.
25 is there, man.
This is there.
Existing.
July 2009, part 2. Where is it? How do you distinguish it?
Lordship, one page 6, lordship.
Huh?
Page 6.
Page?
End of the table, lordship.
Page 3.
Page 6.
6. Yes.
Lordship will see all existing one column is there, eco-sensitive, eco-friendly. One note, lordship. Lordship will find note there.
All existing non-nutrient, non-polluting uses to continue in the following usage zone: residential, commercial, industrial, semi-eco, composite. All existing non-nutrient uses may be allowed to continue, discontinue the application for special permission to the authority in the following use: eco-sensitive or eco-friendly. Now kindly see here that down below, all notified forests,
Water bodies.
water bodies, rivers are classified as eco-sensitive zone. Also, either entire other areas went on Gorsuk Pamohi Road out of National Highway bypass under Deeporville down in land use zoning are classified as eco-sensitive zone where existing government institution will not be affected. To be permitted in commercial area to be indicated in the residential zones. Then therefore, this cannot be eco-sensitive. It has to be eco-friendly.
Here it is been specified as eco-sensitive.
Where?
Same note. Lord.
Where is it mentioned that no, this area is eco-sensitive? Where?
What lordship has read is part of the note. My lord, even commercial is activity. Go down is a commercial, so it is active permitted.
No. Yeah.
All
Yes,
existing
recreational, commercial, public,
non-polluting uses to continue in the following use zone.
after application for special permission. So you can take a special permission and do it. That you can very well do it. But it has to be first we have to find out that it is not the eco-sensitive, but eco-friendly. Now
I think, my lord,
eco-sensitive.
all notified forest, water bodies, etc. classified as eco.
Yes. So therefore, if you see this map, I think you don't have a colored one, na?
Yes, I have. They've given my.
The colored one?
Yes.
Okay.
They've
Now,
annexed
if
it to the
you see the colored one, kindly see eco-sensitive, eco-friendly, Annex C.
Yes.
You see hill, reserve forest,
Eco-sensitive,
river.
eco-friendly. But they give a slash, my lord.
So everywhere they have given a slash.
Ah.
Now you see hill, reserve forest, river, bill, nala, and other areas. Now this area falls in other areas. You see down below.
Yes, I've seen it.
So it will be an eco-friendly, not an eco-sensitive. Because you have categorically mentioned here which will be there.
Is Postim Boragaon. Other. Highway पर खुला खुला
In fact, this area which otherwise will fall will be now they are making a road towards the airport.
6, 4, 6.
On the left hand side of that road will be eco-sensitive. That highway which is going, they are making a road bypass. From there it will from Pamohi side. On the, in fact, why it is being made? Because they have an elephant corridor there. If I remember correctly. I don't think his land falls there. Because tomorrow, if you are doing it, you are having that Sohid Udhan in this area. This very area, you have the Sohid Udhan which has been made just next to the scientific college. This is the area where they have given the land to the district court.
Which was not accepted by the High
It is not, it is given to the district court which was given around 25.
Approach road was slightly narrow.
No, the approach road is only 12 feet or 13 feet. And if it, no, or maybe made 15 or 20 feet. But till that area, if you go there, it's around 3 kilometers. And in certain areas, there is no way except near the scientific college where you can extend it. But I think the government may have to extend because it is a huge construction being carried out, the Udhan, the Sohid Udhan which has been made, where they have made it very beautifully, the Ronghor and all. They are making it out. Have you visited?
No, I haven't visited.
It's a very beautiful one. They are making it. They made a very big arch and all out there. So one day they have to.
Otherwise, the area is a beautiful one, lot, and road can also be extended.
Now, the road can be extended. There is a huge
They acquired the land.
No, here in this area it is not a problem. But while initial approach of around 1 kilometer, it will be a huge problem because huge godowns are there on both sides. In fact, you are having godowns there, by the way. The entire area has godowns, if I am not wrong. So here they can very well apply for the special commission.
Yes.
For the eco-sensitive, because it will be, in fact, a eco-friendly zone. It can't be eco-sensitive. I'll give you a chance out there. Just find out once as to whether, from you ask your people out there, as to whether it will be the eco-sensitive taking into account this. And then, if that be so, if it is an eco-friendly, they can make an application for DIA. Now, as regards the construction permission which has not been, this court is not going to interfere with that order. I am not going to interfere with that order, but the only thing is, if it is what you call, it will absolutely dependent upon the authorities to take a call what is to be done if they file an application.
Yes. If it is compoundable, they will compound it, or otherwise they will deal
It is not compoundable, Mr. Counsel. It is not compoundable. You can compound anything which you have. So there is something. Here there is nothing. How can you compound something?
No, my lord, there was a general amnesty scheme was announced by GMTA. And my lord, that will.
No, that is not. And therefore, as you have now taken the decision that you are not going to go ahead with that proposal of 12/3/2020. So in all these cases, this court is not going to touch on the idea of you there because this is absolutely within the jurisdiction of the authorities to decide. So that is okay, but only just find out as regards whether it is eco-sensitive and eco-friendly. Because I think it is eco-friendly as is apparent from here. And if you are holding it and if this court comes to and holds this to be eco-sensitive, you may have further bigger problems to take care of in that area. Because as I could see,
huge problem.
It's a very huge problem because as I could see out there while going to inspect that district court's premises out there, there are huge godowns on both sides. In fact, there was initially the government thought of giving us a plot of land out there nearby, there just behind that district court premises, around 150 bighas of land. But that would be a huge problem with this. Anyway, we'll have it when? When can you get your instruction?
After vacation, not immediately.
Okay, we'll have it on 23rd.
23rd.
Is the matter again on 23rd?
It will be on 8th of February. See, after 8th, from 8th, I'll come. 1 week I'll take off.
You're coming on 18th? You're coming on 18th?
18, I may come.
18th, you just get that in nothing there. Only
No.
then I can finish it. Because unless it is a 2015 matter, to fix it after 8 doesn't look like. This is the matter again on 18th at 2 p.m. for further consideration. Only there. You take this book. Yes.
Can you have a look of the order dated 1910?
Yes, we have filed affidavit.
Affidavit has been filed, my lord.
They have filed the affidavit.
We have filed reply. We are not
No,
filing.
They have not required it. They have admitted that I have executed the work, but the burden they have shifted to the water resource department.
My lord, approval has to be from the
To make
concerned, my lord,
payment,
department for
to make
execution of the
payment
additional
of
work, my lord. That is, my lord,
the work
uh,
executed by him under the
Water Resource Department, paragraph 6.
Yes, Lordship, in this regard, I will have to take.
Right. You are not a party to the proceeding.
Yes, Lordship,
You don't know what is the department going to say, the deputy commissioner is going to say.
Lordship, I have not received the affidavit. That's
Mr. So appearing on behalf of the water resource department submits that he may be permitted submits that he would like to take instructions in view of the affidavit filed by the respondent number 6. List the matter again on 29th of January.
29th will have prior to or after.
On 9th of February.
Okay.
And then you give him a copy.
My lord,
You give him a copy.
my lord.
But the last order is Lordship, they were supposed to take some instructions.
Oh, there is some payments made. Submits that for the financial year proposal for granting aid for running the halfway home for mentally ill in respect to was submitted to the government, but the sanction is yet to be received. Yes, madam, any instruction?
My lord, that lordship, that has already been placed before your lordship, but again, order is there, my lord, that as per that order, my lord, we have not received instruction, my lord. May I pray for some time?
Okay,
Because
Ms. Yudas, the learned additional senior government advocate, submits that the instructions which have been sought for from whom?
from my lord, Director, Social Justice and Empowerment, Sampel.
There is there another lady which was appearing on this on behalf of that?
My lord, later I have seen, my lord, in the file, my lord, 28/11/2023, my lord. Mr. J. Hendrik has written to the.
You are appearing for the director of social welfare.
My lord, Justice and
No,
Empowerment.
that social justice and empowerment is no longer here. So appearing on behalf of the director of social welfare department seeks for some accommodation to take the updated instruction in terms with the order dated 2011-2023. To list the matter again on 12th of February 2024, on which date Mrs. Yudas, the learned additional senior government advocate, shall obtain such instruction without faith.
Lordship.
Apply the.
Yes, Mr. Roy. You have constructed without permission.
No, I have permission.
Where is the permission?
But LED.
Show me the permission.
Page 35.
Page
35. Selected.
35. Issue of permission under section 1 of the Iman Act of so and so. Your application to erect the restoration building of so and so. You have the permission. Then
And Lordship, I had applied Lordship for constructing E+3, a small plot of land, only 10 acres.
Hmm.
And according to that, Lordship is to come to page 30.
So they have given for G+2.
D+2 Lord.
They have given you the permission for G+2.
Yes.
Yes.
permission
Now
for
what has
that
happened?
D plus a Lordship is to come to page 37A. But the plan Lordship which was, it was for 3 stories.
Hmm.
3 stories Lord.
Hmm.
This plan was the petitioner is an illiterate lady. By 6 days he constructed a hut, but the permission was only up to second. Then Lordship, a so-called notice was issued by the municipal board, Nagaon Lordship,
Hmm.
that your Lordship may come to annexure page 39.
Ah.
In the name of Krishna Das and Babul Ahmad. There is no such person in the name of Babul Ahmad, and Krishna Das is one of my neighbors. They are having their second line in between.
So you want a notice to be issued to you?
Yes.
Okay. Issue a notice, matter in.
No, my lord.
No, here you see 37A. See the building?
The
It is
3
ground floor, first floor, second floor. It
Yeah.
doesn't have on the above anything.
No, they have opted permission to be recorded for G+2, but they have already constructed G+2.
Understood. So now they want a notice to be issued to the petition.
No, my lord, that notice was issued in the name of Babul Ahmed. Correctly said, Babul Ahmed is not the owner of the house.
Huh.
But in response to that notice, the present petitioner submitted some documents. They responded to the notice. So the matter came to her notice. And thereafter, she has submitted the Jamabondi copy over which the land is house is situated. Then thereafter, the permission for construction and one agreement with the neighbor for construction common one. And after going through that permission, which was accorded by the municipal board, it has been found that permission was made only for G+2, but G+3 has already constructed. Therefore, the additional floor constructed illegal. Therefore, final notice was issued under section 177(1). And she was asked to either to remove or to demolish it.
Hmm.
That is.
Then?
Then he came to the court. This
Huh?
court. Then he came to this court here.
Very well. What is this court going to do, Mr. Roy?
So, so-called notice is a foundation of the case, Lord. When the so-called notice was not issued, Lord, they were directly.
Now, did you submit a reply to the so-called notice submitted by
What
to
happened,
Anima?
Lordship, my neighbor, Lordship Krishna, he has handed over a copy of the so-called notice.
So did you file a reply?
I submitted. Some documents were sought. I submitted.
So
I submitted. But
wrong mentioning of the name does not have
Lordship,
any.
in the affidavit of instance, the municipal board has admitted that no so-called notices were received in the name of the petition. Lord. And thereafter, Lordship, when the demolition notice was issued, Lordship, in the name of the petitioner, Lordship, then I filed an appeal.
Mr. Khan, the best option, why do we traverse and make it so long lengthy? You issue a so-called notice. Let him submit and do within 30 days you complete it, and then if they don't do anything, demolish it. That is his only case. Why should we go into length and breadth out there?
Ultimately, Lordship, he knows.
Let him have the survival of means happiness that just prior to Bihu he has got the order in his favor. But at the end of the Bihu, the order would be disastrous for him. His only complaint is that he knows everything. He has done everything. But anyways, if I can very well set aside all this contention. Unnecessary thing will be on that ground an appeal will be filed, which would be not in your interest. This matter will again get delayed. So you finish it up within 1 month or 2 months. Matter is over. He only wants a notice. He's going to give the same thing.
As you, Lordship, please.
You are only concerned with that.
There is provision, Lordship, for compounding under the Municipal Act.
You are look up. I am not on that. You do whatever you.
But it is not compoundable, my lord.
Eh?
It is not compoundable because additional
I-
is not compoundable.
You finish up this thing within April. I'm sitting here till April.
Purpose notice page 39.
The petitioner herein have a sale. Why you are challenging the show cause notice?
Lordship, under the Act, purpose notice is a must mandatory, then only.
Why are you challenging the show cause notice?
No, I am challenging also this page 38, demolition notice.
Oh, okay, you challenge the demolition notice is okay, but the moment you are challenging the so cause notice having been not given to you, huh?
Foundation is the so-called notice. Because
Understood, but
under the
so cause
Municipal Act, without
notice,
hearing, demolition notice cannot be issued without giving personal aid.
the hearing was given. Don't make that
No,
submission.
hearing was not given. Simply
Hearing
they
was
submit
given.
Document I submitted.
No, then why did you submit your document? And what is this appeal?
That was wrongly filed, my lord.
Why?
Wrongly filed the appeal under section 296 before the deputy commissioner. Not an appeal.
For
was
what?
preferred.
This is the appellate
Because-
authority, Lordship. Any order passed by the municipal board, appeal
Because-
lies to the DC Lord.
Then
During the relevant
I
time, the
filed the
deputy
appeal,
commissioner
he
himself
told me,
was
no,
the
you
chairman,
file
in
before
charge
the
of chairman.
executive officer. I tried to file the appeal before the executive officer of the municipal board. Municipal board executive officer told me that DC has prohibited him from accepting the appeal. Then I sent the appeal through by registered post. Till that nothing has been done. That appeal is pending.
During that relevant time,
However, statutory authority was refused to act on the appeal.
during that relevant time, my lord, the deputy commissioner himself was the chairman in charge because the schedule of the elected body has been expired.
Mr. Count, you will be troubled because your municipal board was superseded. And after amendment
there
of the
is-
Assam Municipal Act,
No.
Act,
I think,
the supersession cannot continue more than 24 months.
but the
Prestigious
laws
to
were
have-
amended 3 times.
There are many other costs.
Laws were amended.
who is
3 times.
Krishna Das?
Krishna Das is
Your
one of my
tenant.
neighbor.
Your tenant.
No, never.
Where there is a deed of agreement?
No, common wall lot. He is my neighbor and his name is also shown in the Jama Mandir.
The instant writ petition has been filed by the petitioner being aggrieved. At the notice, notice dated 9/6/2021 issued by the executive officer in the name of Sri Babul Ahmed and Srimati Krishna Das, and the demolishing notice dated 22/9/2021 issued under section 177(1) of the Assam Municipal Act 1956. For short, the Act of 1956 issued by the Executive Officer, Nagaon Municipal Board. From a perusal of the writ petition, it reveals that the petitioner is the owner of a plot of land measuring 10 lesas covered by Dag number 237, a patta number covered by Dag number 1227, included in patta number 237 of village Nagaon, Kismat, Moza, town Nagaon. Full stop. It has been stated in the writ petition that the petitioner had applied before the Nagaon Municipal Board for granting permission for construction of G+3 storied RCC building, which was granted by NOC dated 19/1/2016, and the plan was approved by the municipality for the construction of the 3-storied residential building. To support the state statement made in paragraph number 4, the petitioner have enclosed the NOC dated 19/1/2016 and the approved plan. Full stop. At this stage, this court, however, finds it very pertinent to take note of that the petitioner did not enclose the application which was filed before the Nagaon Municipality.
Municipal board.
Nagaon Municipal Board to the writ petition. However, this application could be found from Annexure A to the affidavit in opposition filed by the executive officer of the Nagaon Municipal Board. From a perusal of the said application, it clearly reveals that the petitioner had sought for permission for G+2 storage building. This court also finds it very pertinent to take note of Annexure 3 to the writ petition, which is the NOC dated 19/1/2016. From a perusal of the said NOC, it is categorically mentioned that the sanction for construction of the building was ground floor 379 square feet.
Not
First-
square feet, my lord,
Huh?
only feet.
No, square feet.
Oh, yeah. Yeah.
First floor 584 square feet and second floor 584 square feet. There was no further permission being granted for the third floor, fourth floor, fifth floor, and sixth floor. Full stop. Further to that, the NOC categorically mandated the front setback as well as the rear setback as well and the side setbacks of the said building. The height of the building was also specifically mentioned at 32 feet. The approved plan has been enclosed as Annexure 4 to the writ petition. From the said approved plan, it is also very clear that the approval was granted only for the ground floor, first floor, and the second floor. Be it as it may, the petitioner herein had constructed the ground floor, first floor, second floor, as well as the third floor, for which a notice was issued to Srimati Krishna Das and Sri Babul Ahmed on 9/6/2021. Full stop. The petitioner herein, on coming to learn about the said notice, approached before the respondent authorities and submitted some papers. However, there was no hearing granted to the petitioner, and subsequently, the order dated 22/9/2021 was passed, thereby directing the demolition of the third floor in terms with Section 177 of the Act of 1956. It is under such circumstances the petitioner has therefore approached this court challenging the notice dated 9/6/2021 as well as the notice of demolition dated 22/9/2021. This court have also perused the this court have also it is also relevant to take note of upon filing of the writ petition, an order was passed on 10/8/10/2021, whereby notice was issued and there was a direction that and there was an observation that the impugned notice, there was a directive that the impugned notice dated 22/9/2021 issued by the executive officer, Nagaon Municipal Board, Nagaon, pertaining to the petitioner shall remain suspended. The interim order thereupon has been continued from time to time. The respondent number 3 has filed an affidavit in opposition, the contents of which are mentioned, have already been mentioned while narrating the facts supra. The petitioner thereupon has also filed a reply to the said notice, to the said affidavit in opposition on a reply to the this court, upon hearing the learned counsel for the parties and upon perusal of the materials, is find that the petitioner was not issued the notice, in a show cause notice prior to issuance of the demolition order, and issuance of the demolition notice dated 22/9/2021 by the executive officer, Nagaon Municipal Board. Full stop. The notice though was issued to one, his name,
Babul Ahmed.
Krishna Das and
Babul Ahmed.
and Babul Ali. Notice though was issued to Krishna Das and Babul Ali. But the petitioner alleges that due opportunity was not given to the petitioner for submitting her reply, as well as also a personal hearing to the petitioner. This court, after hearing the parties, is of the opinion that as the demolishing of the petitioner's building would entail civil consequences, the petitioner is entitled to a notice prior to initiating any process for demolition. Under such circumstances, this court therefore sets aside the demolition notice dated 22/9/2021 issued by the executive officer, Nagaon Municipal Board. Full stop. However, be that as it may, this court makes it very clear that setting aside and quashing the demolishing notice dated 22/9/2021 shall not preclude the respondent Nagaon Municipal Board to take appropriate action in accordance with law.
Lovely.
The demolition notice, Lordship, Chairman, Executive himself mentioned that you were accorded permission for G+3 second line.
That was a approved plan where you were saying your paragraph number 3 is wrong.
They have it. They have it. That was really clear.
Where? So, Mr. Roy, kindly, that was, see, when you mention that it is a proposed 3-story building, that does not mean it is it would be, if it is G+3, it will be
Permission was up to only
proposed 4-story building.
second.
Permission was given only to here, and height is 32 feet meters. Anything happens thereafter 32 feet. Demolish. What is this?
Sorry. My lord, I am appearing for respondent in WPC 7184 of 2021. And my lord, I have filed a writ petition WPC 5449 of.
Yes, what is your case?
My lord, here before my.
Last occasion, your lordship has about to dictate, then there is a no proper translated copy of the sale deed pertaining to item number 34 petition.
Taking into account that the translated copy of the sale deed on the basis of which the writ petitioner claims right over the land has not been brought on, this court grants 4 weeks time to file an affidavit in the trick.
Yes, regional affidavit I have filed. I have brought my sale deed, 1966 sale deed. Our case is that we have purchased 205 duck. They have purchased 202. But after 2009, when resettlement operation done, this petitioner, when tried to give this revenue, said that your name is not in the record. Then he applied for the demarcation, and demarcation proceeding started. And the Lat Mandal says that the land shown by you is in the name of others. So
it comes to this private respondent. Then they have served notice. They came with reply that yes, in your land 205, any demarcation made, I have no objections. We are in 202. After that, it does not to logical end. 2018 through minister, again this repetition are applied and another proceeding to he applied for his demarcation after 5 years when though no logical end of this earlier proceeding. Then another proceeding started 2018, and then they approached this honorable court, says that already that was pending by second. So at today after 10 years, my lord, simple demarcation was not done. So your lordship, other than the express is desire to send it to this them for demarcation. Both parties will be there. So and because sell it is not in proper manner, so by rejoinder affidavit, I have brought a restricted copy of it.
Where?
Rejoinder affidavit.
Affidavit, rejoinder affidavit filed by
Deed
the-
of settlement.
It's not a sale deed, my lord, deed of settlement.
Oh.
How could
My
there
lord,
be a deed
by-
of settlement be a
Well,
registered?
they
sale
are
deed?
they got settlement from the government 95.
And they
We got settlement from Doloi, and my lord, this by paying money and by they have received then given us this conveyancing also, my lord. If I go through this in 66, my lord, this land of Doloi is the representative of my lord temple.
This is not a sale deed at all.
And mutation was done, and they haven't also sold it, my lord. They got it from the government in 95. We got in 66, and we have not clash of interest with them. They are 202, we are 205.
Who is the owner of the land?
My lord, here, my lord, your lordship will find.
My lord, Boshisto Temple Authority.
No, my lord.
Huh?
Our land, our case is this Boshisto Temple Authority was the owner of the land for betterment of the temple.
Wait.
My lord,
First,
my lord, in our sale.
No, Mr. Who is the first among both of you?
I was the first.
Yes.
34.
Let me give him a first hearing. Then your anxiety will become down when I ask.
Just I showed it that when second proceeding started.
Understood, Mr. Borua. First, let me
Yes, my lord.
hear
My lord,
him.
like-
Yeah.
yes.
My lord, this Boshisto land was taken over by the government under the 59 Act of Charitable Institution.
When?
My lord, it was taken over. I have annexed the document at annexure
No, that's a very important thing.
page 14 of in my read petition. In my read petition, page 14. 5449 of 2019.
Page 14. So that is a very important document.
Yes, my lord, here is the government document. Your lordship will look in.
Page 14.
One.
Settlement of land with Shyam Sundar Garodia.
These are the private
and Rohit Tukkar. No, this is not good. When was it taken by the government?
My lord, here it was settled with me on paying revenue at 95. In 62 onwards, we are paying rent to the tenant over there. That is why we are in position. Government has settled with them with us in
So
1990.
it was acquired only on 5/4/1967.
62.
Where 62?
My lord, here your lordship will find that such and such. My lord, in the next page, your lordship will find that Samsudha and Rohita Agrawal has been in possession of the land since obtaining lease purchase on the same on 6/7/1962, page 15.
No, Mr. Kindly come to page 14.
14.
The second paragraph.
My lord, thereof the land in question measuring such and such other land acquired under the provision of Assam State Acquisition Land belonging to religious and charitable institution, 15 as per the notification dated 67. It was taken over by the government in 67. Prior to that, under the Tenancy Act, my lord, the Boshisto has given tenancy to these two persons. One is my lord, their names, my lord.
They were only tenants.
And then after that, in 67, it was taken over by the government. And it was settled under the act who are in possession over the land.
So you were settled.
Settled. And this is the document, my lord.
Where?
Page 16, your lordship will find. The governor
Yes,
is
the
pleased.
governor is pleased to settle the land measuring covered by tax number 02 dated.
And the land he is claiming of 205 it belongs to Bholaram Das. Now he, in his writ petition, he has continuously has written, I purchased the land, purchased the land. Now he comes with an affidavit showing that the deed of settlement of 66.
Now what is happening? Why
Now
have
he
you
wants to
no,
get
no,
a direction from this
Mr.
court
Roy
to
Chaudhary,
be the owner of the land.
wait. Do
In his
not be
writ petition-
directing the circle officer to cancel copy or otherwise copy of giving effect to the stated mark. What is this notice?
My lord, as regards how you are in possession and purchase of that land, give me the reply to it. That was the notice issued to me.
You are thereby directed as per the instruction. Who is Nepal son?
He is the person.
No, he is Doyle Chandra.
His son.
Doyle-
Yes, his son.
Doyle
Nepal
Chandra-
has expired. Doyle has come.
It's a son of
Speaking
Nepal, my lord.
because-
Nepal originally got the settlement or he has purchased. And a
Which would have been done by the civil court. He has come.
mutation,
235. What is this 235?
My
And
lord,
where
that
is
number.
and where is your patta issue?
My lord, this is the settlement. Then, my lord, your lordship will find another notice. I applied for that for correction of my record. At page 18, your lordship will find.
And
Page 18. And my page 17, I filed before the circle officer. There was a deputy commissioner written to the circle officer that I have asked for correction of my land record.
Hmm.
That
And-
was page 17.
and-
Then page 18, they have called me in 2014. Then my lord, I replied to all these letters. Page 20 onwards, I have replied page 22. I have replied for all my how I have acquired, where is my patta, what is my and the land which he is claiming belongs to some Bholaram Das. And he doesn't have any possession, neither he has any title, neither he has any sale deed. Now he has come with a writ petition to declare from the writ court that he is the owner of the land. His prayer is for the direction to being the owner of the land.
now, how are you revealed that you have been holding land in dark number 2335?
It has after renumbered. 20.
So it is still a government dark.
No, not a government dark, my lord. It
So,
has
no, why the notice says about 2335? Doesn't say anything
my lord,
about
renumbered. The old dark number has become a new dark.
So you have not been issued a patta?
My lord, here I have been issued a Jahamandi and Patta. I have replied
Where?
there, my lord. In my reply, it is there. Your lordship will find my reply at page 22.
22.
22 onward is my reply.
No, show me where is the patta issued.
My lord, this Patta was there, my lord, in that particular, but if your lordship allows me, then I have to file an affidavit with the Patta.
Now kindly come to paragraph, page 23, paragraph 5.
Paragraph 5. My lord, it was settled with us.
A copy of the order of, this is 95.
95, that I have shown me already. Annex
And
one.
a copy of the, and were included in the Jamabandi of KP Patta number 239 of dark number 202 of 658 new.
Right.
So dark number 202 is the dark.
Dark.
Then why you are saying about 2355?
My lord, 2355 has been renumbered.
Because this notice would have otherwise said about some patta.
My lord, because your lordship will allow me, then, my lord, I will file an affidavit with the Patta that I have been. Because they have
All of
filed
you are
a
not clear.
deed of settlement.
I think we need to take the help of Mr. Talukdar. Mr. Talukdar, what is this?
What's it doing? There's no impact
Eh?
till now.
I think this is a matter pertaining to 2023 late part. I think.
My lord, 19 and
So 19
and 21.
matter till now no instructions, and I think this must be somewhere in Majuli.
no, my lord.
No.
Devala
It's,
at Guwahati.
Oh,
Guwahati was
so far off. By the time one keeps rolling out there and goes out there, then also he'll reach early. Well,
last
get your
communication, Lordship, I'll take the instruction.
okay,
Last
this is the
communication.
matter again on 24th of January 2024 for on which date Mr. B.J. Talukdar shall obtain the instructions from the respondent.
So one thing, my lord, our,
Mr. First, let me be clear with one,
yes, yes,
then I will be clear with the other.
Yes.
First, you don't have a settlement. What is this settlement business you're on?
my lord, here written,
Now tell me what type of settlement he is giving. The
because
Doloi,
they received.
he has not sold the land to you.
Sold them, my lord, it's written that receiving certain money, I have sold for the betterment of the temple. After that, handing over possession, again 1,000 is taken. After that, mutation is done by purchase and possession. In the report, it is reflected. After that, revenue is paid. But 2009, suddenly his name is deleted. That is trouble started. That is to the
Get the instruction. 24.
apply.
Yes.
Please. The petitioner is having a sweet shop in the Kahlipara road.
Yes, sir.
Sweet shop, sweets.
Sweet shop, yes.
The photograph I have annexed at page 40.
Hmm.
And he has purchased this particular shops from the promoter of that particular apartment, Kiran Hansepa. And in the will kindly see the schedule, which is at page 34.
Hmm.
Page 34.
30?
34. Yeah.
Hmm.
Page 34, commercial shops 2, 3, and 4. These are under the approved plan of the building. And 2, 3, and 4, so and so with a proportionate share of land measuring 0.25 R, so and so. And down below, Lordship, with exclusive right to use 1018 square feet open area in front of the shop subject to the statutory protocol. And there, Lordship, in front of that exclusive position with 1018 square feet, he has erected a temporary shade for in order to safeguard the customer from sunlight and wind. And now this particular apartment, residents of this apartment, they have raised a complaint. And Lordship will kindly, for a moment, peruse page 40, the photograph.
Where?
Page 40, 40. 40 of it. This ingress and egress of the particular apartment is totally different. This particular shopping block is totally untouched with the apartment.
Where is your shop?
Shop is the name is reflected, Nazi Sweets. This is the extended set, and shops are 2, 3, and 4. 3 shops are visible below the set.
It's only a shade.
Only a set. And thereafter, Lordship, they raised the complaint. Order was issued. We went for appeal. Appeal also, it is.
Where is the order?
Order, the final order, Lordship, is at page 49. Annex 11, page 49.
Now,
Now,
you
Lordship,
wanted to regularize.
yes, sir.
Is it regularized? Can it be regularized?
Well, as per the building bylaws, it can be.
We'll turn to straight away turn to the page number 34, madam. My friend had already shown, my lord, that particular schedule. And here the builder has shown it that he will exclusively use the setback area of 1018 square feet provided by the if he had provided it is provision of law, statutory provision. It is subject to statutory provision of law. Setback area cannot be used, my lord. And he was using the front setback of the building as extended shop area of the building. And you had my friend had shown the photograph. These photographs are a bit deceptive. This is the actual photograph. Well, this photographs are clicked such a way it to show that the Nandi suite is as is shown at the wall of the building. Actual photographs are this. How this it has been extended without any permission in violation of the setback area. This is the extended portion without doing business in the setback area. Running a shop, we have no difficulty because this is the commercial part is commercial, he can run a shop, whatever he likes. My lord, if Lord goes to page now 42, my lord. 42, he was given a letter to show the NOC, and he stated went to the appeal.
Mr. Das, tell me one thing. I've seen your sale deed. The sale deed is only in respect of shop number 2, 3, and 4. Now, that is the area which has been falls within the builder's allocation.
Yes.
Is the front side area? Does it fall within the builder's allocation?
It is within the Pata land.
No. You have been sold only that.
Yes.
Is the front side area of 1018 square feet, does it fall within the builder's area?
We have been,
Couldn't have.
but we have been
If you
sold to
kindly
the
see,
builders.
kindly see paragraph of your sale deed. Kindly come to page 27.
Yep.
Whereas so and so after completion of the entire residential, including the shop room, now intend to sell commercial shop number the front side of the building, which are exclusive builder share as per the agreement dated so and so. So he could not have sold the earlier area or couldn't have given right in respect to the front area.
But in the schedule specifically.
No, he has given, but does he have the right to do so? If you do tomorrow, whatever may be, that is exclusively which, because everybody has been sold a proportionate area in respect to the land.
Yes.
All the builder, all the flat owners. So under such circumstance, everybody has a right over the front side.
No, Lordship, the thing is that will give rise to another dispute, Lordship, whether the builder has the right to sell that portion.
Absolutely. If the builder doesn't have the right to transfer that, because your right arises only on the basis of this.
Yes, sir.
And if this right categorically says that only 640 square feet was the area which the builder had on its share, which have been transferred by way of you for payment of 45 lakhs, how can you use any other area? Because you see, you have been only sold a proportionate area of the land. Remaining is the land, which every flat owner will have a right.
That is the specific area of the apartment lot. It increased and upgrade. That does not have any relation with the particular shopping block. It falls within the for the exclusive use of the shopping.
They may like to put their cars in front of it.
No, Lordship, is
it said that the no cars can be put outside?
No.
It belongs to everybody. That was a very particular plot of land which have been given exclusive use to everybody.
But Lordship, the thing is that we went for regularization of that particular paper.
How can you go for regularization of that? No, first of all, do you have a right over the land?
this schedule has given us the right.
That schedule, you see, a person has to have the right over the land to give you the power. You don't have a right over the land for asking for regularization.
No, Lordship, the things that as because 1018 square feet has been given for exclusive right use of the
How? Show
That's
me.
why-
No, you show me from some document. Yes, the builder had the right over that 1018. He didn't have.
then
He
we'll
couldn't
have
have.
to-
Had.
we'll have
Is he categorically mentions in the sale deed to that effect, on which the right has been given to you, is that this is the only he had the 640 square feet, which is his builder's share, which he has transferred to you. All other portion of the land belongs to everybody. He will like to have, he will like to have.
But Lordship,
The only thing is you settle it up with them. You are appearing. See,
We are not against to settling up.
he'll like to have one speech a day, something like that. Yes.
It's the setback violation, right?
no, Lordship, this is not a
And settlement
as-
violation. You have to keep it as per the NOC, as the approved plan.
First of all, the question of regularization doesn't arise. The regularization can only be done by the builder. You can't ask for it. You have no right. How can you ask for regularization if you have no right over the land?
But the Lordship is well aware of the fact that the schedule has given the right.
The schedule cannot give a right unless the main the main thing which is there. This does not give you a right, and therefore it says the subject to statutory provisions of law.
But
He made that last line out there, which you may not have looked at the time of signing.
I have read out. But what I am submitting, Lord, these
No, not you. He did not. Your person did not have. Did not look into it. The last three lines.
what I am submitting, Lord, is a temporary set, not a permanent contract. So it falls under the compound.
Why
compound-
there are so many lights and all?
No, Lordship, it is from the roof. It is the CIC covered.
So the temporary thing you should be
It's,
heavy.
it's iron rod over the iron rod.
So it will be easier for them to demolish.
No, Lordship.
Then
Lordship, may I take one inspection whether the builder has any right to apart from this particular document?
18th, 19th.
Lordship.
Is the matter again on 19th, on which date Mr. DJ Das, the Learned Council, D. Das appearing on behalf of the Learned Council, Mr. D. Das appearing on behalf of the petitioner shall obtain instruction as to whether the builder MS Chief Realtor had the exclusive right over the 1018 square feet of the area in front of the commercial shops of the petitioner. That's the issue.
Not
Short.
That's the
We'll
only
come
issue.
to the later on about the setback. Because the setback question will come later on, but the main thing is whether he has the power to ask for regularization.
I can take with the photographer.
Uh,
Problem.
39.
Yes, what is this?
Document filled with last order method 11 to
Yes, instruction.
What is this RTNH?
Right.
Yes, Mr. Nath, you are paying for whom?
For the PWD and this thing.
Oh, in one matter, I've asked the chief engineer to be present.
In 23,
PWD is not appearing.
item number 20.
Ah.
I'm from
I said that if the council is not represented, the chief engineer shall be.
we missed the item because PWD is not.
So
I have taken.
I've only asked when if the council is not.
Road transport and
Who is giving the sanction? You.
yes, yes.
Then how can we drop their name?
Mm.
Anyway,
They
whatever may be, I think some time has to be given to you
Yes.
in view of the fact that the Kala is going to take appropriate steps. You
Yes.
are paying for Kala also?
no, no.
He is appearing for PWD. He cannot appear for Kala. Kala is for somebody else. Otherwise, you keep on appearing for Kala.
But after having knowledge of this letter, I have asked the PWD officer.
Huh?
After having knowledge of this letter, I have asked the PWD officer. They have said that already the Kala has received this letter, and accordingly Kala has already sent the instruction to the PWD, and the PWD is going to in the portal particular portal,
Bhumi Rashi portal.
Bhumi Rashi portal. They are going to do whatever is required by within a day or two. Thereafter, the MOT will take the
We have it in the month of March,
March.
first week of March.
Yeah.
Pursuant to the order dated 11/12/2023, Mrs. S. Borwar, representing the central government, has placed on record a communication issued by the Assistant Executive Engineer for the Regional Office Civil, Guwahati, of the Ministry of Road, Transport and Highway, dated 5/1/2024. It has been mentioned in the said communication that there were 15 additional plots of land which were not included in the earlier estimate. And as such, now the competent land acquisition authority, the competent authority for land acquisition, that is Kala, is taking appropriate steps in that regard. This court have also heard, the said communication is kept on record and marked with the letter Y. This court have also heard Mr. D. Nath, the learned counsel appearing on behalf of the PWD, who submits that the proposal have already been received from Kala, CALA, all caps, and the same would be duly put in the Bhumi Rashi portal, so that the same is sent to the Ministry of Road, Transport and Highways for doing the needful as regards the sanctioning of the remaining amount. He further submits that this aspect would require some time for which certain accommodation have been sought for. Listed again on 4th of March 2023, on which date the councils appearing on behalf of the Ministry of Road, Transport and Highway, the PWD, shall apprise this court as regards the further update as regards the sanctioning of the additional amount.
Sorry to interrupt. Item number 38 here was an interim.
Interim order है तो आपको extended till the next.
Thank you.
Yes.
The petitioner was selected.
Before my
For
learned
a
senior starts,
dealership, my lord.
before my learned senior starts,
Huh?
before my learned senior starts, Your Lordship, I am representing IOCL, led by Mr. M.K. Chaudhary, Your Lordship. His very good friend passed away today, and he had to leave the court on that account. Is indisposed on that account, Your Lordship. So if the matter can kindly be part for another day, maybe tomorrow, day after, subject to my learned senior's convenience, I'll be grateful, Your Lordship.
Your lordship has already heard the matter. Let it be tomorrow.
Which matter? I have not heard any matter. Earlier, all these
Only
things.
question is, my lord, whether a nominated member,
Huh?
nominated member of the council is an employee.
He then,
He is an employee. So his last question, Lordship wanted to know how the nominated members are appointed. Because my lord, nominated members are not an employee.
oh, yes, yes,
That-
yes,
that-
I remember that matter.
RBI along
You have produced those documents out there, na?
Yes.
To show that a nominated member, and you have filed an affidavit to the effect that he does not take any amount or something to
Yes.
that effect. Or is-
Also, how many hours of work he is required to
Hmm, yes.
during the session, my lord, 1 or 2 hours. Whether and plus, my lord, they have already
anyway,
given to a
Well, we'll have it some other day, not so soon.
not to him.
And subject to your lot final consideration, the direction which was passed on 9/10/2023, pursuant to which my learned senior had filed an affidavit that materials to bring on record to show the responsibilities and duties of a member of the KAC. The attendance sheet has been appended, which shows that there have been 4 days of attendance by the petitioner. And beyond that, your lordship may be in that regard.
Mr. Sharma, you're Mr. Sharma. If you are going to argue
No,
on
no, no,
that,
I
you know
apologize.
what
My
is going to
my senior
happen.
would
This
argue.
court is immediately going to take up the matter.
No, my senior would argue the matter, your lordship. I'm just,
Then don't make all these submissions.
yes, I apologize.
Yeah. Mr. M. Sharma, appearing on behalf of the IOCL, submits that the matter is been entrusted to Mr. M. K. Chaudhary, the senior counsel, to appear. But however, on account of his bereavement, he is not in a position to appear before the court today. This is the matter again on 6th of February.
6th of February.
It's on a Tuesday.
41 Ingrid.
Yes. What is it?
Regarding illegal and unauthorized construction.
Huh?
Regarding illegal and unauthorized construction. The department was supposed to,
Illegal and unauthorized construction.
department TMC has filed affidavit today.
You have unauthorizedly constructed.
Yes.
Then?
G+3 permission was allowed,
Ah.
but they constructed G+6.
Then?
Then the notice was issued from TMC and JMDA, and that is pending since May 2023.
Okay. Then
Against-
we should
against the
immediately direct them to demolish.
My
What do you want
lord,
to-
my lord, we have
When?
already issued notice, my lord.
Before, who after?
Notice was of May. The same notice was issued in May 2023. Since May, they are sitting over.
My lord, thereafter, my lord, they filed appeal, my lord. Respondent has filed appeal, my lord. That appeal has been disposed of on 2/9/2023, my lord. After 2/9, my lord, 4/1/2024, my lord, we have again served notice to the respondent, my lord, for demolition.
But they have filed affidavit today, when they have come to know, madam. Maybe traffic copy, madam.
Who are you?
I am the respondent of 4, madam. Against whom allegations are there, madam.
Yes,
She has filed an affidavit today, madam. I may be given a copy, madam, so that I can get a chance to.
Who is constructed?
That's number 4.
Respondent of 4, madam.
And you are the petitioner.
I am the petitioner.
And how is the petitioner concerned?
I'm at I'm neighbor to that.
We are brothers, my lord. Both brothers, madam.
Your brother?
As he
Oh, yes.
filed-
Why you are fighting amongst you?
Yes, he violated the norm, and he constructed consume more than the admitted FR. I am not getting the permit.
Oh, you are not getting the permission. Okay. So the moment it is reduced to 4, then you can.
Yes.
Hmm.
It reduced to 3, G+3. The permission was for G+3. He
Now,
constructed
now you are not getting permission.
Yes.
You want to construct now.
Okay.
Miss Miss P. What is
Yes,
it?
okay.
As the learned counsel appearing on behalf the phone number 5. No,
No, my lord,
respondent,
JMC, my lord.
respondent number GMDA
GMC.
JMC, respondent,
appearing on behalf of respondent number 2 and 3 submits. You have filed an affidavit.
my lord, to them.
Submitted that they have filed an affidavit. However, the said affidavit is not a part of the incident record. It has also been submitted by the learned counsel appearing on behalf of the respondent number 5
4 and 5.
4 and 5, that he should be also given a copy of the said affidavit, as various allegations have been made against the respondent number 4 and 5.
Four only. There is
And
an
respondent
allegation
number
against five.
4. So this court directs the Mr. Sutia to take appropriate steps for serving an extra copy of the affidavit to Mr. S. Mukhtar, the learned counsel appearing on behalf of respondent number 4 and 5. So the registry shall also bring on record the said affidavit filed by the respondent number 2 and 3. It's the matter again
I
on
have one prayer, madam. In this case, the respondent number 4, he has gone to Dehradun, madam, for treatment of his wife, madam. Wife is suffering from cancer, madam. He is under treatment at Dehradun AIMS, madam. He is likely to come back by the end of this month. So I am prepared for
the matter again on 12th of February.
this notice. Thank you.
But they have filed the affidavit, the matter has to be heard finally. And that this is in respect of an NIT, my lord. This petitioner, he was supplying past services, my lord, from 2013. And in the year 2023, my lord, the NIT was issued. The condition of the NIT is at page 26. Relevant is at page 27.
Yes.
So now, my lord, page 27, these are the two conditions, my lord. One is, my lord,
Who is paying for respondent number 5? Hmm?
I'm paying for lot to adjournment. My senior is supposed
Who is your senior?
J.K. Goswami. J.K. Goswami.
Yes.
Respondent number.
Matter was fixed today. Why did he go? So if he has done it, that is at his Yes, gotten out of station, obviously for some professional work.
As per Lordship, he is out of station. Basically, his father is medical issue. Medical issues.
What is the affidavit of the government?
government affidavit says, my lord, they admit, my lord, he doesn't have pass. But they say, my lord, on the basis of power of attorney, they have accepted. Power of attorney given by one of the owners. And they say, my lord, that they registered as regards registered travel agent. They said on the basis of GST, they had this been note to the petitioner, he could have also participated on the basis of power of attorney from the.
You were earlier, you were doing
Yes,
the
from
same business.
2013. From 2013.
Paragraph number 7, my lord, our affidavit. Page 59.
Okay, Mr. Counsel, we'll have it on some other day. You just find out one thing. You have a travel agent's registry, not in the GST. GST is different. Travel agent registration or a trade license for a travel agent.
Pass.
Huh?
Page 27.
Of
Condition. page 27 of the deed petition F. The supplier must have at least one spared registered bus of similar capacity in his her name. They say, my lord, power of attorney has been given by some owner. And they've accepted.
No, that is okay. That is okay. I'm not on
So,
that.
yes.
As regards that he has been, the bidder must be a registered travel agent under the service tax of the central excise. No, so he is registered under the GST
Yes,
as a travel agent.
yes, my lord.
Then it is okay.
Now F, my lord. The F,
So you are only on F.
F, because my lord, besides others, my lord, your lordship will kindly see the C and all vehicle offered shall be registered in the state of Assam. The vehicles that are proposed to be provided must not be older than 5 years. And if the bidder is proposed
The
buses-
bidder proposed buses are older than years and an affidavit needs to be submitted by the
submitted by
bidder
the
stating that
seats of the buses are in good condition.
Yes.
Yes,
Now you don't have 3 years.
my lord, my lord old bus, but had the petitioner known that my lord, they will accept it on the basis of affidavit of some other owner, I would have submitted, my lord, this is not clear. I would have participated in the whole process. I would have taken a pass from anybody, my lord. Any pass, my lord. This is not clear, my lord. And lastly, they say, my lord, you must have a pass in your own name. That also they say. That also they are, my lord, compromising that the power of attorney has been given by some. So these conditions are not clear. Had these been conditions been cleared, my lord, with the petitioner who was supplying buses from the year 2013, he could have participated. Things are not clear, mother. It seems, my lord, the real reason
Where were you doing similar business earlier?
yes, yes. Where the petitioner was supplying their buses to the respondent number 5, respondent number
And were there any other person who has submitted tender?
3%, son.
And other 3 persons, they had the buses
That I don't have.
3 years in their name. You just find out, okay? We'll have list the matter again on 8th of February 2024. On which date Ms. E.R. Mohanto, the learned counsel, appearing on behalf of the respondent number, on behalf of the respondent number 3,
1, 2, 3, and 4.
1, 2, 3, and 4, shall apprise this court as to whether the other bidder had the necessary qualification on their own in terms with clause 1F of the notice inviting tender. Yes, Mr. Secretary.
Here, probably I need, I have to file a short reply against the affidavit filed by the respondent TN4, 2 and 3. Sorry, TN4. And my lord, here case is this, my lord. The petitioner, my lord, constructed a house, my lord, which he purchased a building, my lord, of having ground front park. Then, my lord, he purchased the building, my lord, in 2017. So, my lord, in 2022, my lord, I have applied for second floor construction, my lord. And already permission was granted to me. And accordingly, I constructed the second floor, my lord. Meanwhile, my lord, the respondent number 3 and 4, they are the neighbor, my lord, one is residing opposite of the street, my lord, the 24 feet the road. And another is also nearby me, my lord. They do not have any grievances, but only they have said, they have made the allegation in the civil suit, my lord, that ingress and egress, my lord, it may cause inconvenience. So they file a suit, my lord, and that suit is pending, my lord. Now, meanwhile, my lord, on at an instance, my lord,
What do you want now?
No, my lord, immediately after vacation, lordship may dispose of the matter, my lord. Otherwise, my lord, whole matter will go on like this.
You want an additional construction. That
Additional.
construction has been rejected.
Not been rejected. Only now the notice has been issued by the Tinsukia Municipal Board at the instruction of the at the instance of the respondent number 3 and 4. This notice has been served to me. And since the
Are you constructing?
now because of this notice, my lord, already been stopped.
But you are constructing without a permission.
No, after being permission is there. Without permission, no. But
You were given ground plus 2.
on the second floor.
You were given.
Yes.
And then you were constructing.
Yes.
Then there was a cancellation or stopping of that order.
No, subsequently they have said that since in the as per this plan, my lord, they have suggested that this
Okay, we'll have it after vacation.
only for parking.
This is the matter again
On 30th January, Lord, I am for the respondent number 4 and 5. 3 and 4.
30th. 20.
Yes.
Lordship.
20 February.
No, my lord.
Then 19th February, Lordship.
No, my lord.
19 is Thursday. Okay.
Yeah, 20th February.
Matter would
20th.
not happen on 9.
My lord, only I pay, my lord. Not February, my lord. It may be January.
Okay, March. 5th of March.
I think he has violated the everything,
No.
Lordship. How could he
Is there any
read
stay?
jurisdiction in golf?
No,
It is a stay.
no,
It
my
is
lord.
a stay. No.
No.
That is why, my lord, I have this because I have been told, my lord, only because the earlier occasion, my lord, I have not been able to implement the respondent of 10-4, and by virtue of the honorable court order, I have implemented them. So accordingly,
Okay.
19th
This is the
February.
matter on 5th of March 2020.
Lord.
my lord, it will be too late, my lord. Can it be on January last or February first week, my lord? I pay
There's a 19th
I pay
February.
before, Lord.
Lordship has already proposed.
First week of February, Lord. Otherwise, my lord,
We can have it on 26th of January. Are you ready?
That's fine, Lordship.
my
We will,
lord,
we will celebrate the hearing, Lord.
my lord, can it be first week of February?
No, sorry. There is no day. You must have seen so many other matters having been picked. And you see, these matters is not mine. I am a bench 4, bench 5 judge of 2021, earlier 21.
Yes.
These are 23 matters.
My lord, that's
What
true.
will my brother judge say? That look here, this judge out there has fixed all these matters and put it on my head.
Let a construction that has been stopped. That is my head.
Very well. So let's see. I fixed it on a hearing day. On 5th.
5th of March, Lord.
Understand? Mission?
Basically, the Lord.
Yes. What is this?
Lordship, the petitioner here was a right to information applicant, and he sought for certain information with regard to his parental line. And thereafter, he has not received any information from the district circle officer. He had gone for the first appeal, then the second appeal, but he has not received any information. But meanwhile, the deputy commissioner passed the order dated 17/7/2023, whereby he directed the circle officer to provide all the information within 7 working days. The discourse officer has communicated to the petitioner that the documents or the information that he has sought,
What is the information you are asking for?
Lordship, on page 28, your Lordship, Annexure 1. It's actually one part of the parental property has been mutated in the name of one of the brothers, and he has started constructing, your Lordship. So he requires all the documents to take certain steps. He requires to take any steps.
Kindly provide the following as per which adoption of new patta.
The part and parcel of the parental land was mutated in the name of one of his brothers. Without
Now these permissions have been, this information has been directed by the deputy commissioner to give it.
Yes, your Lordship. But now he has come with the communication that the documents are either lost in artificial flood or while shifting of the office. So as such, he is not providing any information, and he has not given any time bound within which he is going to provide the information, due to which the petitioner
If the deputy commissioner has directed,
yes,
and if he has not done so, then the penalty under section 15 not applicable.
Lordship, the same was conveyed to the Chief Commissioner of but he didn't levy any penalty on the dispute circle of.
My lord, we have received one communication, my lord, updated 9/1, my lord. The praise circle officer, my lord, praised for 2 months time. To 2 months time to charge the documents. Because of flood or my lord, the shifting of the office, my lord, there is some, my lord. So misplaced.
He does give the information within 2 months. Matter may be disposed of. The matter may be disposed of, stating that he may provide the documents within 2 months. If he could give the documents, but he himself on page 52, your lordship, he has already said that he doesn't have the documents. It is either doc. 52, your lordship. That's the translated copy. 51 is the vernacular communication that's sent to the petition. Cross 3, your lordship. Fifty-four is the representation is submitted for the law.
You are asking information of certain third party?
Oh, your lordship, it is his own parental land. That the land is disputed in the name of trust. He has the interest in that. So that is the reason he was giving the information, because he doesn't know whom the land has gone to, or it has been source of somebody else. He is not aware of any of it. So in that case, to make any informed decision, he requires a document.
List the matter again on 21st of February 2024, on which date Mrs. Yuta, the learned counsel appearing on behalf of the circle of the Dispute Revenue Circle shall apprise the court as regards the present status of the documents which have been directed on the state authority to be supplied. Let's see what happens.
Lordship.
I've given almost 2 months. Let's-
My lord. Okay.
Because if I dispose of it, it will lead to another contempt.
Correct.
Won't help you.
Okay.
That day when matter came up, your lordship directed them to take inspection regarding the figure of the golden chain at the Guwahati radio station.
Yes.
Lordship, DRI has forwarded application to Shillong Lordship.
Huh?
DRI has forwarded application to Shillong Lordship, and we have received affidavit. Kindly allow us time, 2 weeks time to file our affidavit.
Your name?
M. Deka,
Appearing on behalf of
SCKR, SCK,
which department?
Custom Lordship.
Appearing on behalf of Custom Department submits that some time is required for filing the affidavit. It submits that the affidavit will be filed in 3 weeks from today. This is the matter again on 12th of February 2024.
Much obliged.
In the meantime, the Customs Authority can file the affidavit without delay.
Much obliged.
Yes.
On the last occasion, your lordship, I have prayed to seek instruction regarding the affidavit filed by the.
Oh, yes.
So
What
in
happened?
terms of this letter, your lordship, being the chairman of the monitoring review committee of the project, your lordship. So money can be released, your lordship, because the district magistrate has recommended.
You are going to release it? When?
Okay, 3 weeks time maybe.
Mr. H. Puragoin, the learned standing counsel appearing on behalf of
NABARD, your lordship.
NABARD submits that taking into account the specific stand taken by the Deputy Commissioner, UPR,
UPR, lordship.
in its affidavit, the authorities shall would be taking appropriate steps for releasing the amount of 4,63,000,
4,63,000, your lordship.
4,63,000 to the petitioner. He submits that the same amount is likely to be released within a period of 3 weeks from today. This the matter again on 12th of February 2024 on an update as regards to whether the said amount has been released. Yes. What is the status?
My lord,
CID.
lordship may be pleased to peruse, my lord.
Madam,
My lord.
I don't understand. Your counsel who was asked out there, why that is the problem. Different counsels appear and she has given this to you and she has left.
My lord.
That is the problem.
My lord,
Because on the last occasion, on 7/9/2022,
my lord,
this matter has been all along been represented by Mrs. S. Sharma.
my lord, today,
Now, there was a specific direction by this court that the girl who has returned back has made a statement that both the girls were in a particular doctor.
lordship,
The state CID to examine the girl who has returned back in order to obtain any information as regards the particulars of the doctor who was with the missing girl.
my lord,
This the matter next week.
my lord,
Thereafter, the matter comes up on 8/1/2024.
my lord.
Now, therefore, I ask as to whether the state CID has taken any action.
Oh,
What is this?
lordship.
This affidavit, what is this? The parawise?
Maybe my lord, taken up, my lord, the next week, my lord, sorry, my lord, after vacation, my lord, due vacation, I will file the affidavit. my lord.
Okay. Huh? Affidavits have been filed. Everything has been done.
My lord, basing on the, my lord, instruction now received.
No, no. I'm only asking you a specific thing. There was a specific direction by the court out there on 7/9/2022 that you see there were two girls who were there.
Right.
One was recovered, the other could not be.
Lordship.
Now the question is, the one girl who was recovered, she said that she was with the doctor, both of them. Now whether the state CID was asked to find out as to whether the doctor would be traced out or not.
No.
That's all.
Lordship.
So get that
Regarding the
information out
doctor,
there.
that whether, my lord, I'll.
The learned counsel, Mrs. Yuda.
Lord, the accused person also arrested in connection
Huh?
with this. One of the accused matter who brought the girl's matter, he was also arrested. But two effective actions.
We'll see.
Lordship, I'll
Reach the
take,
matter again on 19th of January 2024.
lordship,
On which date Mrs. Yudas, the learned additional senior government advocate, shall apprise this court as
Right.
regards the communicate as in pursuant to the orders dated 7/9/2022 and 8/1/2024 passed by this court.
lordship.
Madam,
I'll
you
take-
write to them.
No,
I
my
think
lord,
she has not informed.
my lord,
The problem arises. That is the
I'll-
problem. She is
I'll
not
take up.
there.
I'll
Alright.
apply.
Yes, you got it.
Yes, Lordship, here, in this case, your Lordship directed me to bring a
Hmm.
status report, my lord, that report we received.
What is this case about?
The missing of the
Huh?
son of the petitioner missing.
Son of the petitioner. What was the age?
It was 20, 19, 1920 like this.
What is your allegation?
The son of the petitioner was missing. He was working with the restaurant 9. Restaurant number 9 is the
But he was 21 years.
Yes.
Adult. Then
it was missing since 18 year old.
Ah.
That then response number 9 informed the petitioner that his son was missing in the night of 3/11/2018. On the next day, he was called. Since then, he has been missing a lot. The petitioner is searching his son. His son is
so you filed an FIR.
Yes.
Why there are two FIRs?
Dear Lordship, on the next day, Dear Lordship, the response number 9 informed that he has lost the FIR. Then this FIR was not available with the petitioner, Your Lordship. That's why I was not able to annex that FIR. And the next on 26th, Your Lordship, the petitioner lodged another FIR.
There were therefore two Jalukbari
Yes,
cases.
yes.
And now it is being investigated by the CID.
CID, yes.
Yeah.
CID, yes, clear, Lordship, both noted status report. They constitute one SIT.
Why did you go to Kualkusi?
Yes.
Why did the authorities go to Kualkusi? This person go anywhere nearby to Kualkusi?
Yes, my lord, yes. The Garigaon, na?
Tarigaon and Kualkusi is different.
Yes. Garigaon,
Okay.
okay, sorry, the petition. Okay.
His name is what? Rakinda.
Yes.
And he was working with Dr. Rubinda.
Yes.
Okay. Rubinda. Now what is happening, Mr. Pugoi?
Now that investigation is going on, my lord, SIT constituted by the CID, but as this report, my lord, they failed to find out any clue. That is the stage now.
Give a copy to her, this one. Mr. B.P. Gogoi, the learned public prosecutor, learned additional public prosecutor, Sam, has placed before this court the updated status in respect to Jalukbari PS case number 1510 of 2018 and Jalukbari PS case number 1768 of 2000. From a perusal of the state report, it reveals that the government of Assam had that the Commissioner of Police had constituted a special SIT for investigation in respect to the two cases. However, subsequently, the same two cases were transferred to the CID on 1/12/2022 and was endorsed to Inspector Kotoy Bormon of CID. It was also mentioned that the State Police Accountability Commission had also instructed that the two Jalukbari PS cases should be investigated by a Deputy Superintendent of Police rank officer and it should be supervised by a SP rank officer. Accordingly, the cases were endorsed to Sri Girindra Nath Deka, Deputy Superintendent of Police CID, and Sri Amrit Bhuya, Superintendent of Police, AAC, CID, on 10/10/2023. Thereupon, the various steps have been taken for investigation, as has been mentioned in the state updated report. And it was further mentioned that all efforts are being made to find out the clue of the missing person and to recover him. because the bid that it made, this court, the said communication is kept on record and marked with the letter. The letter X. Full stop. A copy of the said communication be also furnished to the learned counsel appearing on behalf of the petitioner, so that on the next date, appropriate submissions can be made as regards the investigation so carried out by the respondent court. This court further fixes the matter on 19th of February for further update on the investigation so carried out by the respondent authorities. You just look into it. If there is any loophole out there and anything you can show, which shows that yes, they are not doing it in the right earnest, then only the question of sending it to the CBI would be there. Otherwise, to sending now, in fact, in the recent judgment also, yes, the power is there, but the power has to be very sparingly exercised, because this will be otherwise will have a lot of consequences.
Lordship, I may be allowed to take copy my daughter of this.
He will give you photocopy.
Yes.
Or none appears on behalf of the CPI.
My lord, the petitioner's brother was killed by elephant, and his houses were also damaged. So, my lord, in spite of repeated attempts, the government, particularly the deputy commissioner, has not paid any heed to our request.
What is the
Now, there is a policy of the government that rupees 5 lakh has to be given to the person who has been killed by a wild animal, and also 90
death of the deceased
that I have annexed. my
result of shock and memory due to the injuries sustained by purchase modification of the exterior or loss of human life.
Can you see the order dated 11/8/23?
4 lakh. 4 lakh. When that is the 4 lakh.
4 lakhs and 95,000 for house.
What 95?
For, so this is policy.
Huh?
This is the policy of the government.
4 lakhs.
4 lakhs plus 95,000 for damaging house.
The house is also damaged.
Yes.
How do you know?
Yes, then Lordship may kindly see page 3. Page 5, para 3.
Page 5. No, don't give that para 3. Then this is a question of assessment.
Lordship, from the information that I have received from the department, they are saying that actually this petitioner, there is no record that this petitioner has approached the department. And Lordship, even in the writ petition, there is no representation.
Oh,
as such.
then
No,
why haven't you represented?
that Lordship is the representation we have made, but these are very backward when they did not keep. Kindly see.
No, now they have become forward with you. Then you help them out, give a representation. How will this court take note of you have not represented?
Para 3 may be seen last part.
No, para 3 is different, but where have you informed that you have approached the authority?
Yes, the matter was also informed to Deputy Commissioner, now District Commissioner, in writing by the family member of the deceased who prayed and requested for adequate compensation for the loss of their
Where is
brother.
it? Where is the communication? You have given?
Page 5, para 3, last part. So far, copy is not kept, because
And you approach whom? Who is to be reproached? Who is
he
to
the
make the
brother.
payment?
He is the brother.
No, who is going to make the payment?
Lordship, as per the policy, they are supposed to approach the DFO.
Yeah.
No, Lord, what is it?
Yes, this is by the government, the forest department thing. How are you going to involve the deputy commissioner?
They have filed that we have. They have filed the picture before the DC.
DC has no business.
So that I have
DC
answered.
will give you for public place. Is it the public place? No.
House. The house was damaged and it was,
House is different.
in the house he was killed
It
and
will require verification to be carried out by those authorities.
if that may be done, there is no problem. Here the Kavura
How?
has also given certificate. That
Naumura certificate is where?
yes, that is Lordship may kindly see.
Hmm.
Page
Page 20.
20.
What does it say?
Page 20. Certificate.
Accordingly, this certificate is issued. It is true that he has been killed by wild animal.
Yes.
Where is the? What about the 95,000?
The Kavura, how the Kavura could know that? Yes, he has all the certified.
Naumura would not know that his house has been damaged.
No, Kavura has said that he has been killed by wild animal.
Hmm.
So far, the compensation part is concerned, that is up to the government or authority. So, if we are lordship on that, there is any doubt, then we file petition before the appropriate authority, and the appropriate authority within a particular time shall provide the compensation after due inquiry. In that view,
The instant petition has been filed by the petitioner, being aggrieved by the inaction on the part of the respondent authorities in not making payment of the adequate compensation to the petitioner in
petitioner's
terms with
brother,
the notification dated 6/3/2017 issued by the Principal Secretary to the Government of Assam Environment and Forest Department. It has been stated in the petition that the brother of the petitioner,
late Oghonu
late
Karwa,
Oghonu Arwa, alias Oghonu Kuon, was killed by a wild elephant and is survived by his 4 brothers, namely Onu Karwa, aged 40 years, Rajan Karwa, 27 years, Suresh Karwa, 26 years, and the petitioner. After the death of the petitioner, after the death of late Ogonu Karwa, the petitioner duly approached the Deputy Commissioner, bracket, now District Commissioner, in writing, praying for adequate compensation. However, the said compensation was not paid in spite of the notification of the Government of Assam dated 26/5/2017, which categorically mentioned that payment of ex gratia to the families of the deceased person of an amount of rupees 4 lakhs per deceased person.
and rupees 95,000 for damaging house.
Where is that? You have mentioned that your house has been damaged.
Here.
Where?
This is para 3, last part.
Where?
Yes, can page 5 can see para 3, last part. The wild animal also damaged the houses of the deceased Aganu Karwa, alias Aganu Kamor, who was killed. However, a copy of the said application in writing was not kept here, hence houses were also.
Where?
Page 5, para 3, bottom.
However, they have also damaged the houses of the deceased who was killed. So the deceased was living separately.
Separately means separate house.
Separately.
The same family but separate house.
Only his house, not the others.
No, others have done, but they are not killed. That's why, my lord, they are not.
So the houses are okay.
No, that means let them inquire. If found true, then only we
It
are
has
not.
also been mentioned that the house, the petitioner, house of late
Aganukaro.
Agana Kaura was also damaged, for which the petitioners are also entitled to an amount of rupees 95,000. Entitled to, as per the said notification dated 6/3/2017. First, the petitioner is aggrieved that the respondent authorities have not taken any steps for which the instant petition has been filed. Mr. Aibor Tagore, appearing on behalf of the Forest Department, submits
My lord, forest department is also party here. PFO is also part. Forest department is also party.
that is why he is appearing for the Forest
Yes.
Department. On behalf of the Forest Department, submits that for the purpose of seeking compensation in terms with the notification dated 6/3/2017, the petitioners are required to approach the divisional forest officer and not the district commission. And as such, as the divisional forest officer have not been represented, have not been, as no application has been filed before the said authority, the question of issuance of any direction upon the said authority does not arise. He submitted that a mandamus cannot be issued unless there has been a demand for justice. Having heard the learned counsels for the parties, this court is of the opinion that if the petitioners herein are entitled to, in terms with the notification dated 6/3/2017, the petitioners are required to approach the concerned divisional forest officer by filing a representation, by filing an application and placing before the said authority the relevant materials evidencing the death of their brother and also their entitlement to the amounts on account of damage to his house. As such, the petitioner hearing is given the liberty to approach the concerned, approach the DFO
Golaghat Division.
Golaghat in that regard. It is further made clear that if the petitioner approaches the divisional forest officer Golaghat, the said official shall duly verify as to whether there has been any death on account of the wild animal, on account of the, as alleged, and also as to whether any house was demolished, damaged, and as to whether the house was a mud house or a thatched house. And after making appropriate verification and finding out that, and upon making appropriate verification, if it is found that the petitioners herein are entitled to any amount, the said amount be paid to the petitioner. With the above, the instant petition.
Time table.
What?
The time table.
How? You have not approached.
No, after approaching.
You first approach. You want now to have the marriage cake out there without the baby being born.
All right.
Yes. Aibor Thakur, yes.
Lordship, we have a document that says that a demand is placed for the next budget session, which will be done by February. Lordship may fix it on March. We are hopeful of a positive.
This is the matter again on 11th of March 2023. 24. on which date Mr. Ibotakur shall apprise this court as to the status as regards the payment to be made to the petitioner.
Good. It's about yeah, constant petitioner is the beneficiary benefit for the last occasion when it
Yes, you wanted to file a reply or take a, yeah.
I have called for that person, but he's the agent man. Some days to give it a time. The only thing is that he claims for a 7-pay commission, and they have stated about that they have been paid. But he says that he was only the pensionary benefit was paid only on the basis of 6-pay commission. But he says that it should be entitled to 7-pay commission. That's the only thing. The last occasion when it
No,
came,
that has been happening from since long.
because it was dismissed because
This was dismissed not earlier.
it
This
was
was an
dismissed.
old matter which got dismissed.
it was got infructuous because the counsel was not there. Counsel for the petitioner did not happen.
Ah.
That was the problem. Counsel was absent, my lord, and your lordship was absolutely correct on the basis of the affidavit your lordship has passed the down. On the basis of the your lordship kindly provide me sometime I can place that the affidavit to the counsel.
This court, by an order dated 18/12/2023, had granted accommodation to the learned counsel appearing on behalf of the review petitioner to seek instructions in pursuant to the filing of the affidavit in opposition by the respondent numbers 1 to 7 on 12/12/2023. Mr. P.K. Roy Chaudhary, the learned counsel, submits that he is yet to receive the instruction. Taking into account the above, this is the matter again on 12th of February 2024. In the meantime, the petitioner shall, the learned counsel for the petitioner shall obtain the instructions.
My lord, twice notice issued, my lord, but my lord.
Service not complete.
My lord, we may be allowed to once more, my lord, take a step in, my lord.
Service being not complete, the learned counsel appearing on behalf of the petitioner submits that he may be permitted to take again fresh steps by way of registered as well as usual. He is directed to do so by he is directed to take fresh steps upon the sole respondent on or before by way of usual, by way of registered as well as usual on or before by 12th of January 2020.
Then I have filed this IAM, Lord, because there is a I have filed a petition for correction of name of in the land records of from my father or nephew. But that is not from their affidavit it is learned that they are trying to allot the land to some other party who are not party even in the case. So that is I filed no arrangement can be made.
What? What is the case?
Case is regarding the correction of the land record in our name from father. Earlier land was there, land is still there.
The land has been allotted in your name?
No. It was from forefathers, it is we are legally at.
So what is your right over the land?
Our forefathers' land, my lord.
So obviously your forefathers must be having right over the land.
The right is a patta land.
The patta land?
Patta land.
Then how can they allot the patta land?
In the land was eroded by my lord. In the middle land eroded by river, and now the land is my lord cultivable land. We are in
It is a case of alluvion and alluvion. That's it. Now, they say they have annexed one, my lord. If my lord may be pleased to take up the writ petition, page number 15. Page number 15 in the writ petition.
Yeah.
That is the patta. That is a clear periodic patta. Lordship will see. My lord, it is patta number 44 and tag number, my lord, 89. And the total quantum of land, my lord, is 5 biga, 2 kota, 5 liter. Then thereafter, Lordship will kindly come to page 18. page 18, they file a representation. Petitioner state that land Moza Donia village was eroded by river Chawal Khoa. Land has become government land. Patta number of the land is 44, become external. Dag number 89. Land measuring point so now government dag number, it is required to make the land allotment and then hierarchy. Then it's hierarchy. Then
I don't understand how is this being done? Means he had the land, he had a patta over a particular plot of land. Then that land must have been washed away by the government, by the water. So then it becomes government land.
it becomes because there is no existence of that land. Because there has to be an existence
So
of
how
land.
then it becomes government land?
No, government land in our affidavit we have filed. Even that the affidavit lordship we
No, therefore he is asking for some other land.
no,
No,
that
same land.
no, now he says that my lord it was Deluvian and then again my lord it has been alluvial. That means my lord the land has surfaced again.
Okay, again came back.
Again came back.
That is the case.
That is the case.
Now, only
It
our
again
land
came
should
back
be,
and it-
recorded as a Patta.
Now
But
in-
that is not done, and long time we have filed several repetitions. Even later, ATC has issued letter to
So
the
your land, which was washed away by the water, by the river,
now it is fit.
by changing its course,
Yes.
became government land.
They are saying, we are not saying it is.
How can it become government land?
And
in the affidavit my lord filed by the ADC Borpeta,
Hmm.
Lordship may kindly take up the affidavit that starts from my lord running page 37.
Running page, yes, yes.
37. Lordship will kindly come to page 38, paragraph number 4. Is a reply to paragraph number 2 in the writ petition. The deponent begs to state that as per office Shikha record of Baghbor Revenue Circle, Mondia, dark number 377, land area 17 bigger 3 kota 10 nasa, and dark number 379, land area 48 bigger is recorded as government land, which is also riverside reservation land. Then Lordship will kindly, my lord, come to paragraph 9, my lord, at page 40.
Paragraph 7.
Yes, paragraph 7 it is also there.
The
Paragraph
circle officer has furnished information to the government in the revenue in March, and the
That-
land
that-
in question is recorded as government land. Riverside reservation, and the same cannot be corrected.
corrected. Now,
And-
he has produced a patta. It is his claim that it is a Feraz Miadi patta land. Of course, Lordship is exercising a court of record jurisdiction. Now, my lord, we say that it is a government land. So that is the dispute. We never admit.
Okay. Do you admit the issuance of the Patta 44?
So that is not spelled out here.
What?
My lord, in the affidavit.
What does it say?
Because Lord, therefore, my lord, this paragraph
So
number
what do you say about that Patta 44?
the patta, we do not say anything about the patta. We say
Say
that
something about the Patta.
Yeah.
Then only we'll make it more clear.
yes, that instruction is not there.
Yeah, that is the most vital
Yes.
instruction.
Now,
Because
patta,
if I remember
Yeah.
correctly,
Hmm.
if the land, yes, if the water takes over, I don't think it becomes government land. It cannot become government. Now, on the other hand, if by your side of your land, any further land comes up in view of the river changing the course, that portion of the land also becomes a part of your land. That is the principle of law.
In affidavit, my lord, they have taken two stands. One stand is the land is now proposed.
Let us first find out where is that number, patta number 40. But what is their reply to patta number 40?
yes, they have spelled it out at paragraph number 2 of the writ petition.
Reply to that.
Lordship will kindly compare, my lord, the paragraph number 2 of the writ petition.
Hmm.
At page number 6 of the writ petition. This is their basic case.
Hmm.
The petitioner states that his great grandfather Maharaj was possessing and enjoying a plot of land measuring 5 figure 2 kota 5 lesa patta number 44, tag number 89, old. And the tag number new is 377, 379. So and so, so and so. After death of Maharaj, his son Nevaz occupied the land. Thereafter, Nevaz's son Iman Ali inherited the patta land. Petitioner is a son of Iman Ali residing at village so and so, so and so. It may be mentioned that the above mentioned land was eroded by Sonkhua River. Now the land is alluvial and fit for inhabitation and cultivation. Accordingly, the petitioner and his brothers are occupying and cultivating the land. The DC Borpeta issued patta in the name of Maharaj. Against this paragraph, my lord, 2, Lordship will now kindly come to page 38, running page 38. That is the part of the affidavit. What has been replied? Page 38. Paragraph 4. That as regards the statements made in paragraph 2 of the writ petition, the answering deponent begs to state that as per office Chitha record of Bagbor Revenue Circle, Mandia, tag number 377, land area is, my lord, 17 bigha 3 kotha 10 lessa. And tag number 379, land area 48 bigha 4 kotha.
Understood. These are okay. I'm not saying that.
Yeah.
But what about this patta?
Patta. Good. What about the patta, my lord? That is not spelled out.
So I'll give a better reply to this. Because somewhere the land must have gone somewhere. Whether his basic case is that land will have gone away and now it has come back. So that his patta should be there.
Yes.
This court, upon perusal of the writ petition as well as the affidavit to file, and more particularly in respect to paragraph number 2 of the writ petition, finds that the reply which have been given by the concerned circle officer,
My lord, it has been filed, my lord, by affidavit has been filed, my lord, the additional deputy commissioner
by the concerned additional district commissioner,
my lord,
where
my lord, Borpeta,
Borpeta does not clearly clarify as to whether there was any patta issued. Hiraj patta number 44.
my lord, in the name of one Maharaj.
Hiraj patta number 44 pertaining to tag number 89 old was issued of an area measuring 5 bighas 2 katha 5 lecha
My lord,
in village Heragaon within revenue circle Bagbor, Muza, Zonia
Zania.
in the district of Borpeta
Right.
in the name of one Maharaj. The additional district commissioner, Borpeta, shall file an additional affidavit clarifying the said aspect of the matter.
Yes.
List the matter again on 12th of February.
My lord. And lordship, one another aspect of the matter, they have only, my lord, enclosed, annexed the patta. They said, my lord, that person, namely Maharaj, is their predecessor in interest. After his death, my lord, whether their name has been recorded in the, my lord, record of right, to that extent, my lord, this petition is silent. So they may also bring something on record.
The petitioner the petitioner shall also file an additional affidavit bringing on record
Yes.
as to how bringing on record on the basis of document as to how the petitioner is connected with the said Maharaj. I think that is good to,
Yes,
because their main name may not come out.
Yes.
It may not, because that land will went away, na.
But what
That
they have
one
done,
thing,
my lord, for correction of
the
their name.
land record miller is there, Milord. Kita copy, that copy, Milord, original book is there. That may can be purpose.
No, original Chita is with me.
That is not original. That is a photo. I have original. I have taken it. Original say it was given to me, Milord. And it was Milord. I have found that.
You find out. Try to take us.
It says it is Sarkari land, therefore.
Okay.
Yes. Okay, Lord.
Mr. Borputari,
My lord.
you got the judgment? Kachar one?
Yes, yes, my lord. We are
I've
deeply
reduced,
obliged.
I've reduced the amount from 50 to 10. But there's a very important issue. You have a look at it, more particularly the paragraph number 23.
Yes, Lordship
We-
has extensively dealt with, my lord, that power of cancelling, my lord.
And not only that,
I have it,
the
my lord. Yes,
power of the, I think paragraph number 23,
my lord, I have
the
it, my,
power to the patta,
my lord,
issuance of a patta grants a right,
my lord.
and the issuance of a settlement order grants the right,
My lord.
and the patta regulates in
Yes,
view of
Patta
the theme.
regulates. Yes, Patta is just a, my lord, offshoot. Lordship has recorded. Yes,
Now, if you don't issue a patta,
my lord.
then it is an unregulated
Yes.
settlement,
Yes.
where thereby the government is losing.
Yes.
Because therefore, you see, this revenue regulation was made at one point of time
My lord.
when giving somebody land out there
My lord.
was considered a headache.
Yes. 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 Yes.
So the concept of relinquishment of a patta and settlement is there.
Yes.
The question of not giving or saying that I don't want this settlement is also concept.
It is also there. One can refuse. Yes.
So that all these aspects are there. That
Yes,
I
yes.
can refuse settlement. I don't want it. So
Yes,
that was the patta which was made at that point.
Yes.
So now things have removed,
Yes.
changed. So
Lordship has, my lord, taken, my lord, view of, my lord, that Supreme Court decision as well as Devon Chandra Dekar. Lordship has also dealt with the powers under Rule, my lord, Rule 26.
but when he was arguing on that day, I said to me, shouldn't have been.
I had nothing to argue, save and except, my lord, that.
No, because Devon Chandra Dekar also made it very clear.
Yes,
that
yes,
Sifat
yes.
Ali is not right.
Yes. Yes. Definitely is not.
You can still cancel, if you cancel the settlement, and therefore the last line of paragraph number 24
Yes, my lord.
is a corollary.
Yes, is a corollary. Yes, Lordship is taking into account the above propositions of law as settled by the Supreme Court and applying to the facts of the instance case, it would therefore be seen that the impugned orders have been passed for an unauthorized purpose. And
No. Last but two, 3 paragraph. Just after that, where I have held at that paragraph 23 or 24. There's one paragraph. I think it's just 4-line paragraph, 4-5-line paragraph. Where I have dealt with Jivan Dekar.
Yes, my lord. I'm reading it, my lord.
That it is a, you see, cancellation for
Yes,
cancellation of a patta is a corollary to a cancellation of a settlement.
Yes, look, paragraph 26. This court further finds it relevant to again refer to paragraph 18 of the judgment in the case of Devon Chandra Dekar, wherein it was observed that the corollary to the cancellation of a settlement would lead to cancellation of the patta.
So it will be a consequence of that.
Consequence.
So if you cancel the settlement, therefore the concept of there is not there.
Yes, it is not there. But since, my lord, I had no legs, my lord, to argue, therefore I was arguing that there is no patta. So therefore, Lordship has negated my argument with all respect.
Yes, tell me. What is this? Item number 50. Yes.
No confidence motion against the petition of
Understood. Why the matter has come up? Step the present deponent approach the response number so and so in the respective question of the address of that service upon phone number has been completed and comparison service to complete. Okay. Service upon response number 15 is not complete.
I file affidavit also in Tasti service if he refused to accept in Tasti also.
Okay. Taking into account the affidavit of service as well as the order of the Lozima court lists the matter for admission in the on 29th of January.
May I please, Lord?
So affidavit file.
Yes, I had filed for the respondent number 4.
Very well. So what is there?
Complete, my lord.
So we have it for admission.
Yes,
Lordship.
It is for education. In the meantime, I'll find my lead.
Mr.
Or Ali.
R. Ali, the learning counsel appearing on behalf of the petitioner submit that the affidavit in opposition has been filed by the respondent number 4 and petitioner would like to file a reply to the same. It's the matter again on
Short date may be
9th of February 2024. Interim order passed earlier shall continue.
Master.
Department has not filed any.
Very good, you don't have an object. Yes, what is this?
Service or respondent number 32638.
Enforcement directive.
This is the Lordship, some account has been
Affidavit in opposition filed.
filed by one and two. Lordship, by the
Now,
PD.
who is not filed? Notice upon has been issued upon respondent number 326 by registered post. Who is 326?
These are 325 are by name, Lordship.
What have you challenged here?
Challenging, my lord, the subject matter of this petition is that respondent number 166. They have made a debit freeze of 2 of the accounts lying in the petitioner's bank.
They have
They have made debit freeze,
debit.
my lord, of the account, bank account.
Uh,
They have made the debit freeze of 2 of the bank accounts lying with the petitioner's bank. And the bank accounts are involved in money laundering case.
Lordship, remember this person involved is the same one in that other case
Kohima.
that Kohima. So 2 of his accounts have been attached. That has been confirmed by the company. The section 8 of PML. Now, once it is confirmed by the adjudicating authority, so the amount has to come to the government account. On being confirmed by the adjudicating authority for a period of 365.
No, what is this Axis Bank doing?
Axis Bank is holding his accounts.
Whose account?
That
Kohima.
Ha.
Then?
So he is maintaining accounts in the Axis Bank. So
Ah.
that has been attached by the ED.
Ah.
Again, it has to be placed before the adjudicating authority under section 8.
This is done of a provisional attachment.
Yes. So for
So they have you have done text and steps under 5.
yes, under 5, then it has to be placed before the adjudicating authority.
Under
Adjudicate-
8.
Under 8, adjudicating authority will issue him a no cause notice. He has to reply. That process is over.
Issue to whom? That person.
That person,
And why is the bank here?
because he is maintaining the accounts in that bank, Axis Bank.
So
Now, that account which has been Lordship, attached, the proceeds thereof has to come to the government.
Ah.
So that is what the issue is. So we have asked them to,
but that would amount to confiscation.
but it will be for a period of 365 days.
But
Under-
that would be amounting, that will be done under 8.4.
Yes, Lordship.
But 8.4, the Supreme Court says that you cannot do it for all you can attach it, keep it closed, but you can't take it. Isn't it the law?
Yes. Yes.
If I'm not wrong.
Yes, ma'am.
Ah,
No, if I may,
I think this is done under 8.4.
this attachment, Lordship,
Attached provisional will be
Yes.
done under 5.1.
yes, then
5.5, the complaint will be
I-
there.
I'll just read out 8.3 for a moment.
8.3, yes.
8.3 for where the adjudicating authority decides under subsection 2 that any property is involved in money laundering, he shall by an order in writing confirm the attachment of the property made under subsection 1 of section 5 or retention of the property or record frozen under section 17 or section 18 and record a finding to the effect whereupon such attachment or retention or freezing of the account seized or frozen property or record shall continue during the investigation for a period not exceeding 365 days or the pendency of the proceedings.
But this is still in the form of an attachment.
Yes.
He has no problem with the attachment.
I have no problem.
He has no problem with the attachment or the freezing.
Lordship.
He has no problem. But the moment it is being taken away, which is the power that to be done under 8.4,
Lordship.
There he has the problem. Unless you come up with a finding that yes, is a proceed of the crime, then you cannot. Isn't it?
Yes, my lord. We have no objection of freezing of the account. But the moment he directs us to pay him through a demand draft, my lord, the problem starts.
Because the 8-4, you have the judgment the Supreme Court categorically mentioned in, I think here, Supreme Court also dealt with this in Vijay.
Vijay Madalla.
Yes, that aspect has been duly dealt with 8-4. Have a look. That is the issue. So it is between you and ED.
And my lord, the other aspect of the matter is that the account has been freezed with under the direction of respondent number 1 to 6. Respondent number 1 and 2 is the enforcement directorate, and respondent number 3 to 6 are the other respondents. One is the cybercrime of Hyderabad and the Bangalore police. So the ED has not taken any NOC from the other statutory authority. And if
But why are you making these people by name person?
they have issued, they put the notice in their private personal name, that's why.
How will they do in personal capacity? That is the problem which is happening. He's an inspector of police. Why will a person do in his own personal capacity? Tell me. Because if you keep these people in these names, it will be very difficult to serve it. Because tomorrow, if he goes away, then what happens? Your entire reputation again becomes difficult to enforce it. You are against that 8-4.
Yes.
So your basic idea is that these people have been also consequential. So then if you put it only the office,
Yes, I may be allowed to correct. Because India
for
names
that
that-
memo parties have to be made. Nah?
Yes.
Like you have done number 6. It's okay. 6 is okay because that is an office. But these persons by name, if you do, that will be a big problem. Okay.
3 to 5 years.
I think you should file an application.
I will.
Because this is for removing them by name.
Yes.
Yeah. So you have it only by this office.
I will file an IM.
Yes. Mr. Swanso, the learning council appearing on behalf of. Then what happens now? These are under whom?
These appears to be from the state lordship.
These are state.
Yep.
So then state, can you make them without making the state of Telangana as a party, state of Maharashtra as a party? You see, then there is problems arises,
That is also.
isn't it?
Yes.
So it will be has to be done by those people. So there again the problem arises. Here, cyber economic and narcotic crime, I think there will be, this is some office. Mr. Architect,
Yes, yes,
this will be some office. This is also a police station.
that is police station East Division.
Huh?
Yeah, the police station East Division, Bangalore.
Mm.
Yeah, the state.
So you take appropriate steps by filing appropriate IA.
Got
Mr. Swenso, the Learning Council appearing on behalf of the petitioner seek for an accommodation for filing an appropriate application for making changes in the name of the party. Given 2 weeks time. Liberty is given. The petitioner is granted 2 weeks time to do. What is this interim order again?
No coercive action against the bank. Because they are threatening to take action against the bank.
But the money is still lying.
With us.
Yes.
This is an undertaking. It's an undertaking by you that you are not going to part with that money.
Yes, my lord. It is under
Till
freeze,
this.
my lord. We cannot.
And then I think it is safe.
Yes.
Then it is safe. Okay. This court,
But lordship is just record 1 second.
Yes.
But I will not part with that.
that is what I'm.
We cannot.
This court for taking into account that the interim order has been passed till date. The interim order list the matter. The Learned Council appearing on behalf of the petitioner submits that he will file appropriate application for making certain changes in the cause title of the names of the party. It's permitted to do. List the matter again on 5th of February. The interim order passed early shall continue till the next day. It is, however, made clear that under no circumstances the respondent bank, the petitioner bank, shall part with the money which has been kept on hold. Yes. Yep. The money, where is the order?
Order of better spend, my lord, at
Shall not allow any transaction in respect of account number. There's different account number.
yes, yes, two accounts.
Which are
At page number 147, my lord. I
the
have
page number, I think
147 or 148.
account number.
Clearly reflected.
Yeah, account number 9220 200 316 89839.
And the other one is, my lord, just above.
In the Udyog Bihar branch of the petitioner bank, and account number 921-020-047-829-107 in the petition in the branch in the sector 21C Faridabad ground floor Faridabad branch of the petitioner. So no transaction. So I think that will be.
Yes.
So then your thing is safe.
Yes.
In fact, that judgment, the Vijay Madanlal categorically mentions that you cannot. That is to be taken in very exceptional circumstances. The money should be taken, or the possession should be taken. In respect of, you may attach properties also. Na? Possession should not be taken. It should be kept attached. Okay. Are you best?
Lordship, I received the copy of the affidavit.
2 weeks time is granted for filing the reply.
I'm applied. Service is complete. Respondents are supposed to file it.
Service complete. Okay, list the matter for admission in the second week of February.
Interim is
Okay, on 5th of February, interim order passed.